for the conviction and sentence both of the evidence by the trial made by upheld, not interpret with the bill.
Mate, I take to mention for listing unlisted move today, anticipated and bail application, only case study, nothing more. Create time permit. Highly love.
May I please? Item number 55 bail hearing. Sir. There I want to withdraw it because of the reason, my lord. Two applications were filed, one at the sessions level, one at the high court level. That is in, my lord, apparently, my lord,
Item number
55. So I may kindly be allowed to withdraw the same, my lord, because that would be misdemeanor.
Mr. Kim. 55.
55.
Supplement.
Supplementary.
Anticipated bail.
Anticipated bail.
Third, opted for great power growth and declared
Mine. Highly obliged.
May I pray, my lord? Item number 27, my lord. Daughter of the petitioner is seriously ill, my lord. Can I pray for taking it up as last item, my lord? To them?
item number
27, my lord. It is there, my lord. As last item, my lord.
why last?
My lord. Possibly, my lord. That day also it was in the list, my lord, but it didn't reach, my lord. That's why. My lord. My lord, problem.
Certain matter was taken up to paper.
What?
Matter by the regarding my deposition of different
No,
witness.
what is this bail application?
No, my criminal petition. My lord, because of on 6/26, my for judgment matter without giving the deposition of my different witness. Accused at second the different witness, but due to advocate with heart surgery in Manayana, so thereby advocates are not present. Thereby 6/26 for judgment by closing the deposition of different witness. So last.
Mate, please, lord. I beg to mention for listing of a bail petition, my lord. I am behind the bar for 1100 days, my lord. 1100 days I am behind the bar, my lord. NDPS matter, my lord. But
When have you filed?
I filed it yesterday, my lord. But in this thing, my lord, that trial has not begun yet, my lord. There is no evidence has been examined for last 1100 days. I am behind bar, my lord. The last item tomorrow, my lord. Just my lord may just look into the petition and then whatever, my lord, will follow, my lord.
Necessary, my lord. Otherwise, also.
No problem, my lord. That copy may be looked into, but as in tomorrow, my lord, as in tomorrow, my lord. Deeply obliged.
About 43 days may be taken away with last
All items will be taken.
actually Lord, we are on vacation, that's why. And both of them are behind the work.
Okay, last item. But if it reaches before 4,
Before I'll be there, Lord. Before
no,
what?
before 4:50, nothing will go up. I will take it up as last item before 4.
And I have another.
May I please, your lordship? I am the respondent number 2 of item number 39, hearing matter. This matter may kindly be listed after vacation because my senior is out of Guwahati and leave of absence are there.
Third, Ms.
M. Bhattacharya.
M. Bhattacharya, the counsel for the petition, who prays for an adjournment on the ground of unavailability of her senior with conduct counsel for respondent to the petition. The counsel for the petition does not oppose the The interim order shall not be executed.
Item number 33, minor correction is there. I have filed I. Alright. Please, Doctor. I beg to mention one section, one protected application to be listed tomorrow. It should be like, which has been filed. Is a cross case, Doctor.
May I please, Your Lord? First, I beg to mention bail application for listing of tomorrow. 439.
May I please, Your Lordship? With the consent of the other side, I beg to mention item number 6, Lordship. Lordship may kindly take up the matter after due vacation.
Heard Ms. Gita praise for adjournment. It submits that he has obtained the consent of the other side. Do not have any objection. or break. Let this matter be taken up for
May I please? Now, I pay for listing the case on Kimet on tomorrow, my lord. But the wine has been like, my lord, both of that, very. May I pray, my
It's
I'll-
fixed on 4th January.
Well, I'll take only 2 minutes, my lord, on tomorrow, my lord.
No, it is already fixed on 4th January.
No, my lord, in law court, my lord, in trial court, my thing, matter is fixed.
Similar prayer, my lord, 6th on 4th, my lord. The only urgency here is that is a lady and she has a suckling baby, my lord. NBW has been issued against tomorrow, my lord. Legally okay.
I like to mention two bail applications which are to
Similar prayer, Lordship, tomorrow,
Okay.
4:38 p.m. Yes, sir.
Allow.
Praying for listing this.
What?
Criminal. LBW has been issued.
I have a similar paper listing of a bail petition for tomorrow, my lord, for Mukta.
What is the matter?
My lord,
Offense,
my lord, it is under the Arms Act, my lord. The father has been granted,
special act.
my lord.
It will
What?
go, you have to mention before senior.
I'm obliged.
Lordship, similar prayer, listing of an AP for
The
is a heavy bail application,
pertains to which offense?
120, 420 or 550. Okay.
Please, I beg to mention item number 54 of supply list. Case diary was false, but the information case diary not received. So it may be,
Third, it's
they have to say.
the-
Sure.
Also, the KK harassment. Movement for another date for where is the
Interim.
let this matter be set
Like interim is not there, so
Interim is not.
first week of January.
the first week.
I beg for the listing of bail application, not tomorrow.
Pertains to what? Offenses,
It is under Assam Castle Preservation.
Regular bail, 439 April.
Obliged.
May please, Your Lordship, with regard to item number 12, Lordship, we have got a respondent. This bail application has been rejected by Justice Sushmita Crown, Lordship. On date I forgot, Lordship. Thereafter, Lordship, subsequently they filed a bail petition before this honorable court after rejection. And again, this bail matter has been rejected by this court. And in that bail petition, Lordship, they have not made CBI party. This honorable court has rejected the bail petition without hearing the CBI. Therefore, Lordship, this petition may be sent back to the justice.
It cannot
Appropriate.
be, my lord, the notification says that the bail petition should be listed before the court. We have rejected, last rejected the case, application. Now what happened? At first it came before Honorable Justice Peter, but she rejected it. Thereafter she was in some outlying benches, I think in Itanagar. Then this case was listed before your lordship. Your lordship have rejected it. Now last rejection was by your lordship. It will come here also.
But they have concealed the material fact that CBI was heard by Justice Sushmita Crown on that bail application. Whereas that fact has not been disclosed.
okay, let the matter be called for. Then it
Obliged.
Was filed on 18th
matter pertains to
to this bench only. If you
May it please the connected matter has come before the Honorable Court on 18th of December. The coordinate bench has already heard the matter. The passing of the order was reversed, and the order has not yet been passed. And the matter will be taken up on 3rd of January.
Now, Mr.
Data.
Data. For praise for taking matter on that similar matter has heard by
Court number 20.
coordinate bench of court and order has the considering prayer for the prayer of the considering the submission of the prayer that is again
Third of January.
third of it will come before this court or the
That if the order is passed, if it comes before this Honorable Court, I'll give the order, copy of the order.
third of the before April.
Hello.
Well, here the report was called for, my lord. Report not yet received, my lord. I have already informed the IO, my lord. Maybe taken at 2, my lord. In the meantime, if the report may come.
Reply.
Lord, a similar matter Lordship has already dealt with. That was, of course, in slightly different context. Now, FIR is at page 14 matter. Same FIR. As directed by Deputy Commissioner White dated so-and-so, I, Sri so-and-so is hereby lodging an FIR for detection of unauthorized access of login of Dispur Revenue Circle. That a detailed report in this matter was submitted to the District Commissioner on 12th. That it came to the notice of the undersigned regarding a mutation order passed online in Dharitri portal on 5th of October 23 in case so-and-so, so-and-so, wherein no offline case record of any notice issued, order, etc. was found to be available in the office of the undersigned. Upon inquiry, Lal Mondal reported that neither field verification nor any report was submitted in respect of the above referred mutation case. Having found out the matter, the undersigned officially communicated to so-and-so, requesting for login history details from 1/10/2022, 3, my lord, to 26/10/23. The undersigned examined the records of the login history and following observations were made. An IP address being so-and-so has recorded a recorded history of 52 times from 410 to so-and-so. An IP address so-and-so had a record history of 2 times on 10. That the list of 33 official IP addresses in the office of the Circle Office Dispur Revenue Circle is submitted herewith for reference. The above stated IP addresses are not from the official list of 33 IP addresses allotted to the office of the Dispur Revenue Circle. Hence, access made by above referred IP addresses are unauthorized and illegal, which therefore require detailed investigation and expert examination of the matter during my tenure. Now, my lord, this relevant, my lord, access to this IP address, my lord, it was made in the context of that a transaction of 5/10/23. Now, my lord, issue is like this, and I was also a sub-registrar of the Guwahati sub-registry, my lord, and there is no allegation specifically against the petition. Now, my lord, there are other sub-registrars also who are dealing.
You are also
Yeah, I am also.
within,
Now I have been transferred.
but
Of course, now after this
at
day.
that time you were
At that time, I was there. Now, what had happened, my lord, in the meantime, a notice under 160 CRPC was issued to the petitioner, appeared before the IO,
has been
and my lord, I recorded my statement also. But my lord, having regard to the nature of the allegations and all, I am apprehending, my lord, that I may be arrested on.
Right.
In that view of the matter, I am before your lordship. Idea is to make me a witness.
But one
Yes,
were treated as it's not as
exactly. Even then, my lord, absolutely, my lord, we have annexed that notice also. But during the course of when I recorded my statement, my lord, certain observations were made by the IO, which, my lord, from which I reasonably apprehend. True, my lord. If that position is clarified, that is okay. In any case, now I have been transferred. I have been released also. I have been transferred to Hosai. So, my lord, there is no question of I being present there and to tamper with any evidence or anything. I have been released also.
your
And
apprehension, ground for your apprehension.
my ground for apprehension is, my lord, during the course of the recording of my statement, certain observations were made by the IO, my lord, which impel me to carry the impression.
What of the
My lord, that if you, I
Not
mean, you will arrest you, this and that, this type of, I mean, observations were made. That impelled me to approach your lordship,
no, you
seeking
have
the
stated
protection.
that those of that
Yes, yes,
your
yes. If your lordship will kindly come to paragraph 3, my lord.
ground for your
Page 3, my para 3 at page 5. That the petitioner begs to state that police of Cyber Police Station is charging the petitioner in connection with the above mentioned case. The name of the petitioner is neither mentioned in the Azahar, nor he has any link with the alleged offences. Visit of police officer has very reasonably made your humble petitioner very apprehensive that he may be arrested in connection with this case. For that reason, your petitioner has filed his bail application seeking anticipatory bail before this honorable court. And at para 8 also I have stated, my lord, that petitioner begs to state that on 4/12/23 a notice was issued to the petitioner under section 160 CRPC to appear before Cyber Police Station in connection with this case, and accordingly petitioner appeared before the Cyber Police Station and his statement was recorded by the investigating officer. The petitioner cooperating with the investigation officer, so custodial detention is not necessary for the purpose of investigation for that reason. Well, basically, my lord, I am a government servant. I am on the verge of retirement, my lord. October 2020, August 2024, I will attain the age of superannuation. At this stage, my lord, if I am taken into custody, my lord, it will entail lot many adverse civil consequences,
when police
my lord.
When? after 4/12
Before recording of this statement. Thereafter also, my lord, I am instructed to.
because if it is before,
Ah.
then your apprehension does not have
No, after.
you have not that.
And my lord, in this same case, I'm also praying for an adequate protection on the grounds of parity. Another sub-register of the office, lordship had the
No, that was
on a different context. That I made it a point.
here. I am
No, my lord, lordship is absolutely correct. Since a notice under 160 has been issued, the basic idea is not to arrest. That I also appreciate. But my lord, we never know, my lord, how things turn of events to take. If PP may make that statement, I have got nothing to say.
There is the motion there. Not having my time.
So therefore, my lord, let my learned friend have the instruction. At least, my lord, no
Yes.
coercive measure may be taken.
My lord, here your lordship may see, first of all, I would like to please, my lord, the 27 page, my lord. The earlier occasions, one of the co-register, my lord, sub-register is granted bail by this honorable court. They have annexed. That is, my lord, AP number 421. They have annexed. Interestingly, my lord, he is also in sub-register, and the honorable court has given interim protection. There is some other thing, my lord. His wife was suffering from kidney problems and all that. And
Yeah.
moreover, we have seen, my lord, when this bail order was granted, my lord, they have suppressed the material fact. Because there is an added section
and the section was added on 17/11/2023. My lord, and the adding section is 409, 468, 471. After 1 month, this petition was filed, my lord. That is
No, it is there.
This-
I mean, this would
14/12/2023, my lord.
come to page 2. It is under 4040.
No, it's correct. But the earlier order.
Oh.
Earlier order which was obtained from this honorable court, my lord, is suppressing this material fact, my lord. There's the adding of section 5. That is on
But-
17/11/23.
But for earlier order, you can break or cancel.
My lord,
That's a
yes, of
different
course, sir. We have filed, my lord. But they want parity, my lord. Asking this
No,
annex
not
order.
strictly. No, I am not saying.
They
It's not very
they're saying that, my lord, they want parity. Because, my lord,
No,
they
they do not stand in same. Because
My lord, strictly,
Yes.
I am not claiming parity right, my lord. I have already made my, because their lordship has granted the bail because he was not in Guwahati at the relevant point.
And moreover, my lord, the petitioners with my lord, they came before this court, my lord, with nothing in hand at that point of time, and they have obtained the order, rightly, wrongly. I'm not on that.
no,
If
it
there is a,
not the petitioner.
my lord, yes, correct. But they have annexed this order, my lord, asking for parity, my lord. Similar submission is start from there, my lord. One of the
Parity
co-accused has been granted bail.
Parity is not a.
My lord, yes, correct. On that, my lord, I am clear.
My lord,
Because here-
sometimes we take so many grounds, we don't urge all the.
Because, my lord, today morning, my lord, when we go by the newspapers, my lord, it shows, my lord, the government advocate has suppressed that 409 is not there, my lord. What is the message go to the public? This type of, my lord, message go to the, my lord, society that government advocate has not pressed that there is 409. That's why this honorable court granted it. And now, my lord, this petitioner is the kingpin because I have telephonic instruction from my the police station, my lord, regarding this petitioner. They stated, my lord, there is a fake deed which was signed by the Ranjit Chaudhary, the petitioner. And moreover, the one of the advocate, his name is, my lord, Moinul Haq. He, in his statement, stated that, my lord, 2.2 lakh 50,000 has been given one Nitul Das, who distributed the stuff on the officer of the, my lord, the DC office. And thereafter, this fake deed was, my lord, prepared. And it was signed by the, my lord, the Ranjit Chaudhary. And now, my lord, your lordship may see there are, my lord, total many cases has been registered in Guwahati city. My lord, there are more than 26, my lord, the brokers, employees has been arrested now. And there is, my lord, he is the, my lord, kingpin. And, my lord, at this stage, my lord, the case there is very much necessary to see what is his involvement. So if he is the, my lord, the IP address, password, everything is removed. Without him, my lord, how can a brokers, a staff, how they can, my lord, prepare a, my lord, sell deal, my lord, without, my lord, this petitioners, my lord. He is the main person and the kingpin of the entire, my lord, the incident, what was happened going on in the, my lord, Guwahati city. And there are all these people, my lord, they are running one under the police station, my lord, they need for justice. Their land has been grabbed by the, my lord, brokers and all, my lord. They are doing some fake sale deal. And here fake sale deal was still signed by this petitioner. That was revealed from the, I was just telephoning instruction from the I. So at this stage, my lord, case there may be called for. My lord, he is not in judicial custody. So, my lord, the after case there, your lordship may, if they found any, my lord, the material against him, then reject it. If they found not found, my lord, they allow him to go on bail, my lord. But at this stage, my lord, because he is the superior officer, and now it is very much chances, my lord, he is got internet, my lord, he can change IP address and all that. So at this stage, my lord, may I pray, my lord, on behalf of the state, my lord, not grant any.
My lord, can I reply to what my learned friend said?
Of course.
My lord, my learned friend says that I am the kingpin. If I am the kingpin, it's well, I'm not, I don't deserve any. But question is, what is the basis of my learned friend making that? My lord, question is, if he is in possession of this CD, having perused this CD, if he makes that submission, well and good. That I do not deserve it. But question is it the subjective satisfaction of my learned friend? Lord, it's not that crime is not being done by anybody else also, my. We all know, my lord, people who are involved in crime are holding highest position of the state. Therefore, my lord, this moral lecturing doesn't work. Question is, my lord, I am a government servant. When lordship grants bail, lordship doesn't go by the notion whether I am guilty of the crime or not. Lordship will go by the notion, if I am granted bail, whether there is chances of I absconding, whether I can tamper with the witnesses. These are this. I am a government servant, my lord. I am retiring in August 2024. Of course, my lord, Lordship will definitely take note of my involvement. That is an aspect I am not disputing. But my lord, merely because my learned friend has some subjective satisfaction without the CD, how can he make all this submission, my lord? Then, my lord, if I am the kingpin, why 160 notice was given, my lord? I could have, they could have issued a notice under 41A also. So, in that view of the matter, my lord, my humble submission is let them produce the CD at the earliest. Some third we are reopening, let them have the CD. Till then, if on that day Lordship finds there are mental, Lordship will cancel it. I'll surrender, my lord. I'm giving an undertaking. If my lord,
No,
my
I am not. Both are the report. I have to see whether there is apprehension, your apprehension
yes,
of
that's
getting
my lord. Yes.
that I am not finding. Because you have made statement that 160 is what you appeared before the IO. Still IO did not arrest. So
No,
where
my
is
lord,
the-
I have made a statement. Police has visited my place.
You have not stated when.
Naturally, my lord, after, not before. Before step.
You have to be very specific. Unless how the court will know when police, how I will assess
No,
the apprehension.
no, in that case, my lord, what I can do, I can file an additional affidavit. Lordship will take up the matter at 2 o'clock, my lord, tomorrow, my lord. I'll file an additional affidavit.
Can you bring the case there in court?
Hello, of course, yes, my lord. If it is
So
there,
you
my lord,
file
and
an
moreover, my
addition-
lord, my learned senior friend says I have, my lord, submit before your lordship without having any instruction.
No,
my
no,
lord.
no, subjective satisfaction.
You take,
This is not subjective satisfaction. I have received the instructions
you
from.
take instruction.
Yes, I have taken instruction from the IO, my lord. It is sent to me.
And my lord, Lordship,
Letter,
my
my lord.
learned friend should also have instruction why a kingpin was issued a 160 note.
After
Yes.
Yes, my lord. There will be the investigation is still going.
Senior
No, no, it took this statement আমার ঠিক হলো না। I'll file an additional affidavit.
Public prosecution. That senior counsel during the course of the submission made it clear that petitioner may be allowed to file a such act. Petitioner is allowed to file a petitioner. On the other hand, petitioner public prosecutor submit that the case diary may be produced by
Tomorrow.
therefore let this case be listed
Tomorrow.
My
for case that he meanwhile petitioner may file
My lord, I will take both the points during what transpired during interrogation, statement recording and regarding visit by.
Mato. Item number 8.
Material. Material. Can the matter be for the timing? That
Item 9.
I have not finished the ballot.
none appears for the petitioner or court. Let this matter
After vacation.
after
Kindly pass the code with the technique.
10.
Team 9,
9 we have passed out.
kindly pass.
Really, so many matters are there.
Lordship, machinery taken code number
Okay.
5.
We take it up.
And Lordship earlier rejected by your Lordship. Lordship, in this case, prime is already released on
What is the offense?
Lordship. A commercial quantity, Lordship.
Heroin, my lord.
Heroin.
1 kg, 434 gram.
How many days you are behind the bar?
Lordship, 440.
What is your ground for?
Lordship, now purchased prime is already released, which the owner of the contraband released by on a 49 bench of his.
What ground?
He was released on bail, but he remained absent. Charges have been framed.
Not what ground?
I do not know, my lord. That is, I have seen from the order statement. He has remained absent.
Lordship, page 6, para 7, page 5, it started from page 5, Lordship, para 15, 16, 17, 18, 19.
He was released because the only material was on merit. He was
My lord, charges has been framed, my lord, against them, my lord, on 9th October. My lord, the trial is begun. Trial has begun. And commercial quantity of heroin, my lord.
Lordship, till date, no witness was examined.
No, witness could not be examined because one, this accused was absent. Of course,
they are merit. Merely because co-accused has been released, you will not be.
So, Lordship, otherwise, Lordship, no, till date, no witness was examined, and Lordship,
No, that may not itself be a ground for bail. Because if you go for prolonged incarceration,
Lordship, that is 404 days, Lordship may,
that
that
is
part
not
may,
that is not
Lordship,
long.
earlier already stated, Lordship, that for that, Lordship, we can have to wait some more time.
400,
404.
you have to wait for 6 months.
If otherwise Lordship is not used, then we can take some more time.
You want to withdraw.
Lordship may, matter may keep pending, Lordship.
Instead of keeping it pending, you may withdraw it, or I will have to dismiss.
once XCR has been, my lord, received, we have perused it, examined it. And thereafter, my lord, keeping pending doesn't, question of
Because
penalty doesn't
not-
arise. Either way, it has to be
Then
decided.
close it. Otherwise, well, I will be up.
how it will get hard. The also hard. Yeah. The application sort of right, but if Shamil who has been in my car, 13 for last 4 connection with Bajari Therum is connected with what is in connection with special NDPS case number 159 slash 2022 pending before the court of special judge that if subject for petitioner has submitted that one of the co-accused named Jamaat was paid by one of the coordinate bench and on ground of very great pain with the bar not court how not How many witnesses?
Okay.
Not even. On merit, you don't have it.
One merit lordship, 400, he is the driver. He is the driver, and it was Condavent was owned by Lordship Primary. He was already released on bail. He is the only driver, and it was recovered in the vehicle. That part, Lordship kindly, otherwise, Lordship kindly have a look at page 12 of the bail petition.
No, we are not. On the other hand, contraband is it of commercial quantity.
And charge has been framed on 9/10/23 on.
Charge against charge framed under what
21C 25/29.
25 and petitioner co-accused was allowed to go on bail as paid to appear before the that on the date fixed for recording for that. On which date he has paid,
My lord.
the co-accused has paid to appear before trial
Yes, in the order
after bail,
after framing of court.
after framing of
My lord, I may be given the elsewhere.
That is, I think, not in respect
That
of the.
that is my lord, progress report.
when the co-accused has paid
On 13/10/23, he remained absent. The
He
accused
was
person remained
released
absent.
thereafter, Lord. He
Hmm?
was released on 1st of December.
1st of December.
Or 29th of November. So that may be
Yes,
for
13/10.
the other accused.
13/10. That order is not there.
what is your name?
My name is Kamiluddin. He is the driver, Lordship, and it was recovered from the vehicle. So
What
he,
crime?
Lordship, how he can be? Owner is he is not the owner, Lordship. And also police already recovered the entire chain, Lordship, from which it was
Certification is Jamal Print. Is on payload.
he is the driver, he is not the owner of the contraband.
Jamal Print was released on bail because it was not recovered from his position. It was recovered from this prisoner's position.
From the vehicle it is.
Yes, from the vehicle when you were driving the vehicle.
Considered submission. Appears order
Lordship, may I submit one thing with he take condition, he may be released from it with one. So he will appear with the
no, the question is the embargo of
Lordship, but he is the driver.
but the coordinate bench has observed that you are the prime. Making that observation, he
But-
has
Then I,
on perusal of the order
Yeah.
dated 29/11 passed by passed with bail application 2540 that the coordinate bench of made observation but not made that is prime driver as there are materials on spot and at this stage because of that there are plenty of open start open with which start. Therefore, embargo section 31, 37 of the is as regards the period of detention of the gentleman appears that the petitioner has taken a bar for the 404 which is not long enough to override or prayer for way of the Shamil.
Ethics. Comment.
Make it the last. But what an application? It is a before the lot, the driver of the vehicle man. And what happened in this case, there is a Korea company called Pratik International Private Limited. They are one of the largest Korea having Korea network in India, man. And they
Kote
14, man. I'll come to that, man. So, man, there is a transport company, man. They have a valid agreement with the Pratik International Korea company, man, for transportation of their goods, man. And so what the company does, they loaded their vehicle with the authorized person and they seal the container, man. Seal the container with the company lock having its number. Now, after loading, man, this lock can be broken at the distributorship destination by the concerned authorities, man. So, man, in this case, I'll take the lawsuit paragraph page 13 of the FIR, man. Page 12, man. Page 12. And second, from bottom, my lord, the second paragraph is relevant, my lord.
what is page 12 FIR?
Yes, my lord. The page 12 is the FIR, my lord. From the bottom, my lord, it's paragraph 2. May I read, my lord? The body of the truck was blocked with orange color gold steel block of Pratik V, white block number such and such, my lord. The gold steel lock was broken to open the container body of the truck. So, my lord, here in this case, my lord, when the police vehicle was stopped at the Naka checking, my lord, they found that it was blocked by the company lock, my lord, having its number, and the police authorities, my lord, broken the seal and found, my lord, along with other goods, they found 2,000 bottles of penicillin, my lord, cough syrup, my lord, and thereafter, my lord, this FIR was registered and charge sheet was filed, my lord. And now, my lord, I'm facing the trial. Now, my submission is that, my lord, I was only discharging my duties, my lord, as the driver of the company, and I do not have any knowledge, my lord, what was loaded in my vehicle, in the company vehicle, my lord, and it was blocked. And during the Naka checking, my lord, the materials, the documents which we have annexed, my lord, nowhere suggests that it was tempered or he has any kind of, my lord, knowledge about this. So under such circumstances, my lord, there's reason, my lord, to believe that the petitioner is not guilty of this offense, my lord. So it is my humble position, my lord, consider it.
What other materials apart from the fact that you were driving the said vehicle,
Yes, my lord. And it
in which the containers were
sealed, my lord, by the
from the
company person, my lord.
manufactured can be opened only by
Respective
Right.
responsible person at the destination, man. And when my lord, the vehicle was stopped, my lord, and checking was done, they also police officials also found, my lord, that it was still condition, and they broke it, my lord, and thereafter, my lord, this thing was, my lord, found. Apart from that, my lord, but the documents available with us, my lord, nowhere suggest that he has any kind of dominion over the goods or has any knowledge, my lord, that goods were loaded, my lord, the contrabands were loaded in this vehicle.
Loaded is another thing, but whether he has to produce documents in support of they have carried out with valid authority that 2,000 bottles of coffee. And,
Documents available with us, I have produced at the
Uh,
time of when the vehicle was stopped, thereafter I was I'm behind the bar. For me,
Now-
it's not possible to produce any documents regarding that's the investigating officer
Starship-
inquire about this.
yes,
They could have found mallet.
started only on 31 of 31/7/23, and now last date I have flag mark. Last order was of 5th of December 23, fixed on 18/12 for production and report only.
Charges were not framed mallet.
Charges not yet framed. So this thing may be brought to the notice of the court at the production of charge.
That is one of the different aspects. That will not do the petitioner from claiming
Okay.
relief under 439. Or may I coordinate where the similar issues happen, mallet? Very different mallet.
No, their ground is he was the driver in which he was carrying container which are
Still,
from
Yes.
the manufacturer.
similar
So who will produce the document
Investigation is about done is that
carrying the driver you carry the document?
if the company he has the authority with the company should produce and so at the time of investigation these things
What was found is
Malad?
what was found is
I have not done details in the charge
now you go through it. Why he has been charged? Merely because he was driving the vehicle.
and
Whether
2000
he was knowing that carrying an illegal contract.
Yes.
That aspect is
that is there, but 2,000 bottles of fertilizers were found. And regarding the materials and all these, I have not got enough time. I have to go
let him
after something. That's why
sometime this apparel
No.
very heavy.
let it up
immediately after that.
immediately up. Because it needs I will have to go. You are on merit.
Yes.
That you don't have conscious possession. You are not consciously knowing what you were carrying. That is your sub.
And that
No.
is apparent from
So
FIR.
what document? Apparent from FIR is
FIR charge sheet also, mallet, and charge sheet also, mallet, they have mentioned.
how much time it spent?
Yeah. Immediately to them, not possible.
Yes, they
To them, not
Let it be
possible.
on
Immediately
third.
after.
third or fourth.
Fourth,
Third, Mr. M.A. Chaudhary, also heard that K.K. Parak submit that he has not gone through 10 copy of case report, which has been received by this court. And considering the submissions made by the Council for Petition, individual of 10 copy, that able to submit made by the Council for and wait for some more time. Going and where is up. Let the fourth of
of the
This is ordered by a holiday of 42 of the follower by law. That is the charge sheet of the case by this time. Charge sheet was very minor. Charge sheet was on 22, 30/11/22. And charge came on 22/5/23. And your lordship will find page 20. 20 there.
Since how many
He is here, madam, for To 450 days, my lord, 1 year, 3 months, 1 day.
1 year, 3 months?
1 year, 3 months, 1 day. 457 days.
On what ground you are reporting?
I am on 2 grounds, madam. First of all, because these contaminants that is, it was found outside my bathroom in a, under beneath the tree, my lord. It is on the face of the effect. Second thing is, my lord, during the sunset and sunrise, they have not provided to 42, my lord. The sunset has not been complied. So these 2 grounds, my lord. First question, not requiring for my possession outside my that bathroom. And second question is, supposing that is there, my lord, they have not complied the permission, mandatory permission of 40. Only on these 2 grounds. And matter is pending, nothing has been done till today. Trial has nothing.
No, but
Nothing, not even single evidence, but your lordship charge was framed on 22/5/20. Charge was framed.
treated 1 year.
That is there, madam. If
Delay
your
effect
lordship
time.
find, if your lordship find that, madam, there is a non-compliance of the mandatory provision, madam, your lordship may, my lord, just take your lordship to page 20.
No, one more page before you start. You have to show me the authority that you do not complain of mandatory provision 42. Even bail can be granted. Not
It is there, madam. Last time I argued with your lordship, and your lordship was your order. Everything was mentioned. Everything, madam. Supreme Court, it is mandatory as far as bail is concerned. And your lordship
Even
also, yes, your lordship order, madam, everything is there.
don't show my order.
No, your lordship will discuss as a Supreme Court also. It is not that exclusive, they are not here. Yes, both we have given, my lord.
Last occasion, petition PP was requested to go through the record as whether there was
Yes, LCR is there.
LCR is there.
But
whether
so far
there is
LCR
any
is concerned, my lord, orders of the special court is available till August 2023. Now, whether thereafter any, because charge was framed in May, charge was framed on 22nd of May 2023.
Yes. There are not a single to our information, matter, not single. Take a from, I don't take a 5 on what you look at.
there anything now come to fact.
Now, fact, kindly see that. Kindly to come to page 22. I take your also state to my lord, last part on the program by I along with your lord. Page 20. Your lord got him. I along with police party used departmental Bolero vehicle bearing number so which was opened by so proceeded from PS at 12:40 a.m. with an investigation team waited towards so. On reaching the spot, we laid ambushed outside the house of Paridutya. Thereafter, additional SP headquarters are also arrived at the spot and guided me to conduct the search. We immediately cordoned the house of Paridutya. After that, I, along with my police party, called out some local witnesses from his neighboring houses and offered ourselves to be searched by the independent witnesses with the provision of section so and so on. The following items were recovered by me during the search, which were concealed inside a yellow-colored cement bag, and the bag was kept on the back side of his outer bathroom beneath the tree. That is the my concern. Not from inside the house, from that bag, beneath the tree. The bag contains 60 numbers of soft so that is the quantity. Quantities, my lord, they got 320 grams of heroin, 2 type motor, and 1 methamphetamine, my lord, they total 250 grams is commercial. Then you have page 21. Total your lordship that my lord the decision. Then the cream powder is substance kept inside the plastic packet within a soap boxes suspected to be heroin and suspected Eva tablet was weighed by me with the help of the detail with so. Weight heroin was 322 grams and net weight of Eva tablet 2.so grams. The above mentioned recovered item presence in power so fine. Thereafter, after completion, that is important, after completion of all these formalities, the police party departed from the PO at 3:15 a.m. and returned to the police station at 3:30 a.m. for 19 so. Exactly, your lordship dealt with this in this case also. Right? Yes. In this case also, your lordship will find same thing, my paragraph with the with your lordship order. Paragraph to same timing, same year. Here also during search operation, 7.1 the entire operation was videographed, your lordship. Videographed and was completed at 5 a.m. And at about 5:30 a.m., the seized articles were brought to the Patagandi PS, the possess Malhana so and so forth. Paragraph 2 of your lordship, that's order. Thereafter, paragraph my lord 5 again, and 7 your lord can from 7. Landed senior counsel submitted the MAC perusal of the FIR as well as the forwarding report shows that search operation was started after 12:30 a.m. at night and it was finished by 5 p.m. in the morning. Hence, the search operation was conducted in between sunset and sunrise. However, there is no reason has been stated anywhere as required under second proviso to section 42 of ATPS. Thereafter, your lordship, I have referred to Supreme Court, that is also okay. Your lordship also mentioned. Then again, paragraph 11 also, same thing. Exactly what is covered by this order. Reference to Supreme Court. It is not your lordship order alone, man. Your lordship passed the order with reference to Supreme Court.
Now, this case, whether no reason was
No,
for conduct.
no, man. Record will show and I also my category statement is not applicable. Second proviso to at that point of 43. And executive paragraph 9 your lordship mentioned the compliance with section 42 is mandatory. That is Supreme Court says in Sarjubanu case. And that is a relevant fact which should have been engaged in the court while considering the pay. Exactly, my your lord kindly from the record also, my. Second proviso. Proviso that if such person has reason to believe, my lord, that a search warrant or authorization cannot be obtained without affording opportunity for the concealment of evidence or facility, so and so he may enter and such so and so he can do it. Thereafter, where an officer takes down an information writing under subsection 1 or record grounds on a belief under the proviso, he shall within 72 hours send a copy thereto to his immediate. This is a mandatory provision.
No, which provision violated?
This second proviso, my lord. You'll also have to copy my book, my lord. 42, my lord. First proviso is I am not on first proviso. Second proviso surplus 2, 42 2. If they enter, my lord, there is a chance, yes, it is not possible, my lord, if we get the written authorization, they can do. But after doing what they are required to do is surplus 2 of section 40. Where an officer takes down an information in writing under subsection 1 of record ground for his belief, under the proviso thereto, he shall within 72 hours a copy thereof to his immediate officer. If that is there, I am not case followed, I will not say anything. Only records will show my healthcare. If they comply, please don't come.
There
No, my lord, so far, sunset and sunrise question raised by my learned friend. My lord, the proviso is there, my lord. Without authorization, he can enter. Only, my lord, region has to be recorded. Now,
No.
from the FIR itself, it appeared that they had cordoned the house of the, because there is possibility of playing out the accused person.
No,
Wait.
but whether reasons are recorded.
That my lord, perhaps Kesdari is not there. I could not.
You have to find out whether
Yes.
material is there so that
Yes, Kesdari, that, for that, my lord, Kesdari has to be looked into. Perhaps Kesdari enter, Kesdari is not there. Oh, my God. Situation. No.
you go through.
But once again, I will examine whether, because Kesdari I did not find.
Because
Only
unless
without-
the materials are before the court, how will we verify whether where the was recorded? There may be somewhere in the case that
That means
the record
Yes, it will be
they
recorded.
must record it, otherwise I have a case. If it is there, I am confident. Not very difficult.
so please verify.
After some time. Let it be taken after some, I'll verify.
That's it, sir. Yes, sir.
Sir, Lakshmi, Mr. Nine or seven LCR is there.
Lordship, on the last occasion, I was arguing a point that there was in the sampling process, there was a not the section 52A notification under 52A was not followed. Therefore, it is very unlikely that it will be convicted. Lordship had asked for a authority that when the chances of conviction are grim, that can be a consideration for bail also. That was the query raised from, I have brought an authority. But Lordship would kindly see the fact from the FIR, from the search sheet, from the forwarding report, and from the seizure list. It was not found from my possession. It was not found in my house. It was found from a place, garbage from backside of my house. Lordship, my first argument is, I am behind bars for so many days. It's apparently more than 330 days because 21 commercial quantities involved.
What was the
68 bottles of codeine and some tablets. Now, Lordship, I'll just like to place that if I am not in possession, then 21 would not come. If 21 doesn't come, therefore 21C would not be attractive. Lordship, I may place the relevant provision. Lordship, I will just place the FIR, only the relevant part. Page 10, fourth line. Fifth line, Lordship. The accused Moinul Haq was apprehended at his house and his house was searched. On searching behind his house, one white color plastic bag was found and was kept hidden under garbage at the backside of his house. The plastic bag was extracted from the garbage in the presence of local witness. Lordship, the same thing has been also at page 13 is the forwarding report. The same language has been used. At page 20, 21 is a seizure list. actually finally the charge sheet is at page 29, the relevant. Page 29, 10th line. On searching behind his house, one white color plastic bag was found, which was kept under garbage at the backside of his house. Whether it's within the premises or not, that is not given. So presumption has to be it's not from a garbage.
Now, that is your mind
That is not
from other witnesses.
Okay.
Whether the witnesses
from the backside of my house, as per my instruction, from the garbage. Therefore, Lordship, I was apprehended. Now, Lordship, it is not found from my conscious possession and not found from anywhere. It cannot be said that it is found from my possession. Lordship, the Harshit also, it is not reflected, it is found from my substantive possession. Therefore, Lordship, kindly, I'll read down section 21. Lordship knows it. Whoever in contravention of any provision of this act or any rule or any order made or condition of license granted thereunder manufactures, possesses, sells, purchases, transport, import, interstate export. Therefore, to abstract 21C21, I have to do any of the such things such as manufacturing, possessing, selling, purchasing, transporting, importing.
no, when it is that type of, unless you accept that your it would be presumed that
Now, it is the prosecution to prove that. Whether it is found from my possession, once they prove that, the burden is on proof is on me.
yes, they have stated that
In the search sheet, it is from the backside of my house in a garbage.
no, wherever is concealed, whether that place is within your control or
That is the question. It was not in my control, and there is nothing to suggest that it is my control from the search sheet. Is there better?
but some evidence that some witnesses must point out that that area was this or that he has concealed it there.
Lordship is very right. That place has to be in control of me. That is there are cases where the laborers were sitting in the bag. Then also they were not observed to not be in possession. Ultimately, the control has to be there of the group. From the circuit also, it is nothing to suggest that it is within my premises or
No, from plain reading, how can we come to that was not within your
but for purpose of bail only. Archet would not suggest anything, but since it's a panel status, if there is two constructions, which support the subject, therefore that has to be preferred over the other.
Yes. Yes, any other subject?
Yes, Lordship. Secondly, Lordship would see the third sheet once again at page 29.
Yes.
Last, but the sampling part from last 14th line, Lordship, the FSL report, FSL sample of the three suspected contraband has been sent to FSL Kahilipara for examination and the report has been collected accordingly. The result of the FSL examination of the suspected contraband revealed that the sample is tested positive for codeine present, Lordship, exhibit of 100 ml. Next page. For codeine phosphate present in the exhibit of 100 ml.
Yes.
Lordship, I'll just say this is a notification. It's a notification under 52A of the NDPS Act. Though there are a lot
What
of
is your-
faults in the sampling process, I want to show 2.8 of the drawing of representative samples. While drawing one sample from a particular lot, it must be assured that the representative samples in equal quantity are taken from each package of that lot and mixed together to make a composite whole from which the samples are drawn from that lot.
No, this we can take now. Out of how many bottles, one bottle was sent? Out
Yes.
of how many bottles? The
One bottle was sent for of 100 ml was sent for. But when a lot is 68 bottles, so from every bottle there has to be some amount of in the exhibit that is FSL. Uh, 2.5, however,
and suppose 52A is not complied with. 52A is not complied
Yes.
during investigation.
Yes.
Then for purpose of bail, can it be considered?
yes, Lordship, there are judgments, Lordship, where it says that if the sampling process is not done, it will ultimately lead to acquittal, Lordship.
No. Ultimately, it may lead to acquittal. But at the stage of consideration of bail,
I am just,
better non-compliance of 52A is considered.
yes, it will be a ground. If suppose, yes, for that I am for the judgment. If it is ultimately, if the chances of conviction is grim for this mistake, then it is a consideration for bail. Lordship, I will place this.
In
1978.
NDPS state,
No, Lordship, it gives the consideration for bail. Lordship, I will come to
No.
section 37 also.
we are concerned only with that.
Yes, Lordship, but then I will directly say,
General law will not be helpful. Anything which can jump over 37.
Lordship, 37 embargo, Lordship, is the length of detention.
How many days you have? got fined?
I've been arrested on 22/1/2022.
How many days?
It's around 335 days.
In year, less than a year.
Less than a year.
So I have not come across that. It says that less than a year can be considered as long enough period. Jump over. There are judgments where for period of 1 year, 6 months, apex court has granted bail in terms of prolonged.
But there are 7 witnesses. Now only 3 has gone. So ultimately it will be over. And 335 days is also quite long but for expecting that long incarnation.
You show me it for the 335 days. You can show an authority.
But regarding period of
What is this?
this is the Deepak Chauhan Lordship here judgment. Lordship has referred to the judgment of the
No, there no judgment referred there. There is then permit. In Deepak Chauhan case, all judgments of apex court which are referred, minimum period is 1 year. So if you can show that it's for lesser period than that,
no Lordship. Ultimately the period is not important, whether it is long incarnation or not.
whether it is long or not, but
Long or not.
there
It
is no
is,
scale.
the definition of long is not given anywhere. Lordship, it's discretion of the court in granting bail. That's my humble. It is whatever I submit, Lordship, ultimately it's the discretion of the court. Lordship, in granting bail. The definition of long, Lordship, whether it is 335 days or
It's not long enough, according to my
Lordship, just if Lordship, you have to consider what is long. Lordship has to see what is the statutory period. Well, statutory period is only 180 days. And moreover, Lordship, on facts also it is not under my possession. If not under my possession, then also Lordship 21C is not attractive. Secondly, there is a direct mistake in the sampling process, which will ultimately lead to my acquittal. Lordship, these are penal and technical laws. That are the other considerations. Lordship, only for the purpose of 37, I am placing the long incarnation judgment. So while what is long, Lordship, it is discretion of this court. And I will suggest that anything more than 180 days can be considered as long, because it is it's the statutory period of completion of
it.
That is for the purpose of investigation.
Yes,
And that may become 365 days.
Mr. Das, yes. Regarding his submission non-compliance of 52,
52 ml, this is number one, this is a matter of fact that has to be established in the during the court of evidence. Number one. Number two, 100 ml, at least 100 ml has been sent, and that gave positive test of codeine phosphate. At least for that sample, he is liable to be punished. Presuming that yes, there are anomalies, due process were not followed for collecting samples.
sampling
But
was
that
done.
sample which has been sent, it has given positive test for codeine phosphate. Number one. Number two, then 6 strips of nitrazepam also found. No, that cannot be ground for acquittal. Maybe his punishment may be lesser.
there is
The-
judgment where conviction were set aside on that. Magistrate is also.
And my lord, regarding his conscious position, my lord, it was all the Caesar witnesses have said it was recovered from his residential premises, and he was
Witnesses have said
my lord. Caesar witnesses I have flag marked, my lord. Approach me kindly see. And it is not the case that he was not present at that time. He doesn't say that he was not there. That is, I have flag marked is at SW. Teaser.
Yes,
And so far, long detention, my lord, as has been appeared by learned friend. My lord, your lordship know, my lord, 180 days is statutory period for investigation, and that can be extended up to, my lord, 1 year. And that 1 year even he has not completed. So that cannot be treated as, my lord, long incarceration.
how they was
Yes. But if, now the prosecution says that suppose even for one bottle, but which was sent for exhibit of 100 ml, suppose I am convicted on that, then also it is not a commercial quantity, then the bar of 37 would not come. Suppose lordship and 2.8 lordship, I will place that once again. 2.8 of how 52A was violated. Lordship, at all 2.1, all drugs shall be properly classified, carefully weighted, and sampled on the spot. All packages, containers shall be serially numbered and kept in lots of sampling. Lordship, 2.8, while drawing one sample in duplicate from a particular lot, it must be ensured that representative samples in equal quantity are taken from its package containers of that lot and mixed together to make a composite whole from which the samples are drawn from the lot. Lordship, I thought, and it has some sense. But if suppose one of the bottles is something different, then a different result would come. Therefore, it was made mandatory that from every bottle now has to be taken. Two point five also.
no sampling was done front of legislature.
Lordship, that is not also clear. Lordship, in that case, I will say that it is not done before a magistrate. That is also a that error that has been committed. Normally, if the learned magistrate is present, then it is recorded.
But three people are done it now. Right. For last how many days?
From 22/1/2022.
How many days?
my calculation is 334 days.
for last 3 it's Japan,
FIRS page, uh, page number, Lordship, 9.
one, 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 that is not bad. Japan, that one, that very bad subject. Big bad. That, that, one, last week, that, right, back, that, but now, that, 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 back, it, but, go to, it, 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 Boston, Boston, doctor, it, it, some bit, it, 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 that, it, it, Japan, with a particular system, it, up, it, that, it, that, it, when, that, it, it, charges are made,
That is substance stream under section. When
if it, on the basis of
21.
this chart, chart sheet, NDPS case number 36, that, it, it, that was where there is it on 22 1 page the trial any necessary on 31 6 2000 charges it right there 31 6
Lordship, I have
charges that frame it has to be verified date
I
charges that frame it how many witnesses are required
to my infraction is 3 when I filed it.
now now, that contraband were not as they were not backside is up still in article. Therefore, therefore is submitted and 21 is applicable. And the council for provisions of the made of the Education Act was not complied with it as at the time of appealing the guidelines. What are the guidelines
Point eight, issued under 52A,
by whom?
Gazette notification by the government.
Very, very
It is a section, the clause in section 52A
Yes,
for
sir.
disposal seizure of the narcotics,
pending for
pending order 1 of
one
the
of
89.
89. The mode of extracting sample as described column number 0.8 of state order has not been followed. Therefore, there is non-compliance provisions of not therefore, therefore it is submitted that that be released of pay. Further submitted that same uh, same, uh, yes, yes,
334 days.
and it was not to override the embargo section 37 of the Independence Act, and therefore he submits that on the ground of non-concern that on the other hand that the period of 300 days detention in case involving commercial contraband may not be started long enough time to override the embargo of section 37. And that submission as regards submission regarding non-compliance of provisions of 52 concern non-execution of submission. Prima facie, there is nothing to show that there is a non-compliance, and this plea is a matter to be taken into consideration only during trial of case. Regarding submission made by learned counsel for the petitioner that the contraband was not found from conscious present petition is submitted by learned editions of the prosecutor that all the other witnesses have stated before the investigating officer that the, these contraband were found from the premises of the present petitioner wherein was concealed in the backside of the house of but white house
Garbage.
under the carpet. It was the submit the payment the opposite grant of debt. I have considered the submission complete both sides and have perused the end of your case report. I will go through it and complete the
So Lordship, one of my submission is also that it is, detention is an exception in the constitution.
regarding long
Long duration, that detention in under Article
but whatever order I will pass, but I am not convinced regarding the that
ultimately it's a discrete bail and a decision of the
but
court.
we cannot 37 cases falling mention one we cannot lower the bar of
Yes. Lordship,
otherwise it comes lower.
yes, yes, yes. Lordship, but I may read out the section 30 proviso to the 37 that first thing is that the public prosecutor may be heard, and there are reasonable grounds that I have not committed the offense.
There I
Yes. Lordship, that is also so. The proviso, if the proviso is complied with, Lordship, whether the bar would come or not. That's Lordship. Suppose Lordship would not grant me bail for long eternity, but otherwise also, if I fulfill the proviso is fulfilled, if I fulfill the proviso, then Lordship 37 bar would not deeply.
Itu di mana? 8. Malah you lordship may take up the leftover matter 8. I'll take just 1 minute.
which item
That HR 23 was there. I was asked to check whether reason was recorded or not regarding authorization or
there
what. My lord, item 12, my lord. Now we are saying that this is the appropriate court. My learned friend is saying that Honorable Justice Pitapukon court is the appropriate court. Now, my lord, when such type of question arises, then it is very difficult. And the master of roster is Chief Justice, my lord.
third judge should decide.
No, my lord. Chief Justice should.
Chief Justice.
Because, my lord, I have come today to make my submission. And he have raised this issue now. So whenever such issues are raised, he may be right or I may be right. Whoever is right, lordship cannot decide. So I have to wait. I have no option. And this matter will be referred to the Honorable Chief Justice to decide as to his best.
No, I will direct
No.
it will take instruction.
My lord, that order is already there. Registry have listed it before this court. As per registry, this is the appropriate court because this court has last rejected the bail application. Now, if my learned friend raised this issue again, then this has to be decided by the Chief Justice, not the registry. So registry may be directed to place this case before the Honorable Chief Justice, and Chief Justice will decide which court to take up the matter. Otherwise, my lord, last section is by your lordship, but I cannot raise that submission now before your lordship because having the considering the nature of the submission made by the other side, it has to go to Chief Justice.
No, before that, I have to complete my thing. Merely because a plea has been raised, I cannot put my hand.
My lord. Then, my lord. Lordship,
What is your submission?
My submission is that This petitioner has filed bail petition earlier. Lordship. That has been rejected, Lordship. That has been rejected on Lordship.
By coordinate bench of this court.
Yes, by Justice
Yes,
on merit, but not on merit, on the on presented objection as well as other circumstances. That was rejected. Subsequently, they filed a bail petition wherein CBI was not made a party. CBI was not made a party in that case, and state of Assam appeared. And on the motion state, I have got the order. Motion state was rejected. This honorable court has directed the petition to approach the trial court. Subsequently, trial court has rejected their bail petition. Now, second time they have filed this petition. Again, in this case also, Lordship, CBI was not made party. I don't know why the reason based on to my learned friend why CBI was not made the party. Subsequently, in the case when it was listed, Lordship, they made a prayer that CBI should be implemented as a party. Thereafter, we were implemented and we appeared. Subsequently, again, this matter has been listed in another court where my learned friend has made mentioned that it should be listed before appropriate court. Now it is court. I've gone to the order. CBI was never made a party. The earlier order, rejection order, was passed in absence of the
Okay,
CBI.
now the CBI has made a party in the
Lordship.
and where is the bar?
Lordship, bar Lordship already done it. The justice found has already heard the matter in length. After pardoning the case, after presenting the objection, after hearing both the sides, Lordship, that order has been passed.
It was at some earlier stage, my lord. Now,
Whatever.
after subsequent stage, lordship have heard it.
It may not be proper.
Offense is very serious, Lordship. The case where Lordship, the then additional DCP in connivance with this accused person is murdered. That is the allegation. And the murder was very brutal, Lordship. Where 164 section was also there, Lordship, and the witnesses were threatened.
Third, third, same follow investigation. Submitted at bar. He submitted at bar that on an earlier occasion, the petitioner had moved a bail application before a coordinate bench of this court. Within bracket, Honorable Mrs. Justice Smita Pupar. And same was the case. Thereafter, the petitioner approached High Court again, wherein the CBI made a part. Where is the rejection order?
On 14/2/2023, Lordship, Justice Smita Pupar found as rejected. And Lordship,
And by this court,
by this court, on 14, Lordship,
26/7/23.
page
Page 60.
60.
Yes, my
26/7/23, Lordship. In motion state, I think, Lordship, was no other order was there.
Then it was not mentioned that was other
No, no.
Then page 60, there is no mention of other
My lord, what happened? That time, Honorable Justice Pupar found was some other bench, outlying bench.
No,
So-
how it be fine.
Registry with, if registry sees that particular date on 26/7, they can find out. On 26/7, he was not available, that's why he was listed before your lord. And subsequent to this order, CBI had got an opportunity to object our bail application before the learned court bit.
It is a different chapter.
And
We
they
are-
have objected,
we
it
are-
was rejected, we have come again, my lord.
Lordship,
And
we are-
kindly see the nature of submission made by us on 26/7.
It was rejected
Yeah, it was disposed of,
rejected
26,
by
26/7.
rejected by this court on 26/7. However, it appears that there is no reflection state or regarding earlier rejection of
Then lordship, my submission may be recorded during that period.
other rejection order However, in state order, there is no restriction regarding fact of being of earlier bail application, taken care of by the coordinate bench of the court. Senate Council for the Senate Council, which I have done, Senate Council for the has submitted that on 2027, 2023, and Senate, the honorable judge who had rejected the earlier bail application filed by petitioner was not in the principal case of court and was in some of time.
One more submission, that the state rejection order was annexed as annexure 12 in the state bail application.
And
The earlier rejection order dated
rejection was accepted of state bail Senate public prosecutor submitted that Senate petitioner in the coordinate bench court had heard the matter at length for rejecting application filed by at first this instant bail application to be heard by the
in that regard, by the submission may kindly be recorded that this court have rejected at later stage of the case because stage of case is not same. My
however,
That a part of we will not have made a part.
that is stated.
however, Senate Council for the petitioner submitted that by rejecting that bail application number 2543 2023 was rejected by this court at a later stage. That is what later
My lord,
how it becomes at a later
at a later stage, my lord, because
considering the rival submission made by one counsel for petitioner as well as Senate. This court is of opinion that this bail application needs to be tested before it has this case for appropriate bench. In case of any confusion before the it may take appropriate order from honorable
now if this court passes an order that registry should be before appropriate bench, then it
after taking
follows
direction from
that order will be specific. The registry may take direction from Honorable Chief Justice and list it before appropriate.
is directed to take appropriate from it is this case for
My submission may be also recorded. In both the bill petitions, we will not make the part. That should be
We have
noted.
been so
In both
fair,
the
my
bill
lord,
petitions.
my lord. Earlier bail application.
let it be there. Senate Senate special public prosecutor both the earlier bail petition in both the subsequent bail petition, that is bail application number 25.
How can he make such submission, my lord, when we have specifically prayed before the court to make them a party? There may be some mistake, my lord, while filing the bail application, but on the first, since the first
Bail
bail order,
application number 2543/2023 and bail application number 3901/23. Petitioner had initially not made the
The lordship, again my submission is
no. I have used the word initially.
Initially, in this case, Lordship, earlier
My
they have
lord.
not. In two bail application, Lordship. In earlier bail petition, they have not
just
made
for the
party.
sake
No,
of
let
my
me-
lord
let me-
opposing,
let
they are
me-
opposing my
let-
lord.
No,
My
not
lord,
for
the
the sake. It's a
intent should be
malpractice,
seen, my
Lordship.
lord.
How
Intent,
they can, Lordship,
intent should be, my lord, considered by a council, my lord, while making submission, my lord. Since Thursday, we are saying that we had, my lord, inadvertently not made CBI a party and they made it a
inadvertently, how
party.
it can be
Again, they
inadvertently,
have
Lordship?
coming
How
with
that
a
can be done
submission, my lord.
inadvertently?
I am taking
No. Section 42 is violated. My lord, as per my lord, GD entry number 441, dated 19/9/22, at 12 midnight, the secret information was received by the officer in charge of the police station. And as per GD entry number 442, next GD entry, on the same date, at 12:40 a.m., he informed the ASP, Additional Superintendent of Police, Karimganj, IPS, Partha Protim Das, regarding this entry, and the person informant was sent with authorization letter to search the book. So there is no violation of the matter was duly reported to the additional SP.
That is, I am not disputing that part. My part is up close to my. Organization that is there, that is law allowed.
Right hand side, the 441 is the first GD entry.
your objection.
Up close to my. They are past pilot, they are past within, writing that inform. No. Inform to them, I think writing, your lot kind of study, initial stage they have informed. Before going to start, they have informed the additional. But suppose to your lot. That is the reason which your lordship that order also. What if your lot is 42. 42 close to. Where an officer takes down any information in writing under subsection 1, the record grounds for his belief under proviso that he shall within 72 hours send a copy thereto to his immediate officer.
Yes,
That is
he
not
has 45.
information, something like that. Categorically, it is there. That exactly what is there in that with that put case matter. Exactly a lot.
No, it's not post occurrence.
Yes.
This 72 hours regarding I am violation of search.
No, no,
my
that is there. I am not on
my learned friends raised the question that before before sunrise and after sunset, he has to inform the
No,
officer
you
that
are
they are
authorized to do it.
they are
No
has to-
problem.
yes.
They are authorized. They can do my. But once they do it post search, is rightly said post search. That is the problem.
Not it is not.
No, my lord.
42 is after giving the report from some source, you record it in right.
Yes.
And then you have to inform this to your
No,
superior officer, right? That he has found by GTNP. Subsequent GTNP you have informed.
No, for that purpose, not for informing him in writing. 72 hours was in his hand, but immediately he was informed and my lord, process was initiated for uh, for carrying on search operation. As is revealed from the my lord, GDN.
Where is
42, my lord, two violations. I'm only on two, 42, sub 2. That part they can do, my lord, because it is true, my lord. Till night time it is not possible for them. They will have to do it, my lord. They have done in form. No problem. But what they have done subject to the my lord, 42, sub 2, my lord. Yes, you do it. Law allows you to do. But what you have done thereafter?
Even my lord,
It
when
is
there is,
understandable. During night time it is not possible, my lord. But that's why 72 hours is given. These are very minor stringent provisions, so that's why the procedure has to be by the strictly for. This is what Supreme Court says, and your lordship has reiterated that order. So only safeguard my. Once again, my lord, your lordship go through your lordship that order with the Supreme Court.
Now, Supreme Court order says that either if you cannot take authorization or start and start necessary,
That's why the law allows them to do it.
do it by recording the reason.
Yes. Thereafter, that to inform in writing within the
Not there.
your lordship is what 42. Where an officer takes down an information in writing, your lordship.
Not
So that involves because during the night time they have taken. It is not possible to by not send it to a higher official. So all right, you are authorized. Where an officer takes down an information in writing under subsection 1, for record down for his belief under the proviso thereto, he shall within 72 hours send a copy of that to his immediate official. The first part they do, but they are authorized to do. It is but natural, my lord. During night time, it is not possible to. That's why 72 hours is given. Legislature has some intention, my lord, by enacting this provision. Yes,
exactly, my lord. For that reason, whether written information was given or not, to a certain entire case there will be required.
That I have
That's
Exactly.
up to, my lord, up to that part, during night part, they have done it.
And even my lord, memo number is given. Authorization memo
That's
number
true, my lord. That
is also given.
I am
also
not
there.
disputing it.
to find out whether
My lord, no, but entire case, my lord, case there will be required.
This is from case that you have stated.
No, part of case there is there, entire case there is not.
Well,
Because if such authorization was there, I mean, written information was there, it has to be in a Malkhana,
no, it
because
will be there in the case that
or there may be a my lord, copy in the my lord,
whether entire case there is there.
entire case there, my lord, not there.
entire case is not required also. Up to that, the entry was made as the statement of what they are affected.
Case there is you go through it. Whether that
Your lordship has
40
to do it again, way to argue my lord, that part. Your lordship may have everything before lordship. Everything before lordship. Law also I have written your lordship. Fact is also before lordship. Your lordship may go through.
No, so far, my lord, what I respectfully submit, so far GT entries are not 441 and 442. From this it appears that conduct, my lord, search operation was done in accordance with law. There is no violation of section 42. Now, suppose my lord, that that in written information is not there, but GD entry is also there. It is categorically stated that he has been, the ASP has been informed.
And you tell
Now,
42, sub
can this fact totally brush aside the recovery of the contraband from from the position of the my lord petitioner?
outside my bathroom, my lord. Can it be for my conscious possession? It's on the face of the record. The FIR says, my lord. Under beneath the tree, my lord, record. This is the FIR.
It will
Outside
be-
the bathroom, beneath the tree.
Yes, it will be recovered from.
So where come the conscious possession, my lord? How it comes? They cannot develop the case step by step, my lord, just to take it from on. That's the support.
Here there is, according to you, violation
42, but close to. I'm only on that one.
of, I will go through the
My lord, your lord.
part of it. Then go through the headline. Or Mr. H.R.A. The JM. Its application of 39 for has been filed as it since 29 packet for last 1 year deep connection with foreign GSK. It is charged case
Yes, madam. Absolutely.
in connection with special NDPS case not for one that 2022 corresponding
Actually, charge claim, no witness, nothing at all, madam. And it is-
corresponding Karimganj case, Patharganj
it is okay.
Patharganj case certified list of it that on nineteen ninety-nine of the country Raj Pratap had filed an FIR for receipt of it for informing that what body the body the that is represented as state narcotic drug located and kept and in search of different drugs of the gram affected heroin as well as 0.17 point yellow suspected GABA tablet were seen there. It also revealed substantial FIR that it said that it structured during night time procedure described section 44. On a senior counsel for more specifically, there is non-compliance of where it is mandated that after taking out any citing as provided one of or after recording grounds of belief under provider the such a person recording or citing can have sent a copy thereof immediate period within 70 hours of the of within 72 hours. However, the sent submitted by the senior that nothing so that no material record so that it said mandatory required was applied by has further submitted that the senior as per compliance of section 40 of the NTPS Act must identify mandatory and non-compliant is a relevant fact while considering grade application. It further submit code para 9 from grade application. On the other hand, the teacher has submitted the quantity of contraband in case it's of commercial and further that the investigating officer has complied with all the mandatory procedural requirements as mandated. Has also placed the scanned copy of the case record of special NDPS case number 141 along with the scanned copy of case diary of Karimganj PS case number 235 court for. You have any other? You have made that THP so that it, I declared it after it.
The parents are behold what তারপরে যদি
And suppose the his diary does not clear because it is scanned copy. If it is a complete case diary on, I'll go through it.
Let's do same identity. My question was up to that level now. Subsequent is not
Up to 72 of.
yes, that's not.
So if he has complied with, he has to make an
Exactly, madam.
endorsement in the case.
Endorsement the case there is, if that is not there, it means they have not complied.
Or there is a state, there has to be a state.
Something must be there, madam. Suppose if there is no, there is no statement, it means they have not done it. Otherwise, certainly it ought to have been recorded there.
I will put.
But for 13, your lordship, PWC 1, 2, and 3 already examined. If we don't have the copy, my lord. Your lordship may pick up a bit. Only up to the payment.
Up to date.
Up to the status, my lord. Status of that. There is a case, I have a case, my lord, but anyway, I think that will be required, my lord. You were a passenger in the train, my lord.
Mr. H.R. Heard. Yeah. Here. However, name is updated here. Update status report for
I will stick
for of the court of the trial from the trial. It will be listed again on 6th of January.
Right.
6th of 8
8 what?
8
But still, my lord, that last time your lordship wanted to the Pontika. Consider my timing, my lord, and there is a question, my lord. Same, my lord, same thing. The case which just now your lordship participated.
There is a notice note, my lord, regarding updated case record that not yet received.
Third, from office note dated 1912 the updated status report as per court of Fairport by order 30 has not been met to make a set
7, my lord, it is perfect. Idea on its own, that's why.
7th of
On the next. Then I.
Yeah.
My lord, item number 15 and 16, 15 also, my lord. There is a order of this, earlier order of this honorable court, my lord, 29/11/23. Regarding the statement of witnesses if recorded.
Lordship record has come. Petitioner are in custody for more than 2.5 years. Lordship is in custody for 2 years, 8 months.
Your lordship may kindly produce order dated 29/11/20.
After that, got
In this case, my lord, next date for evidence.
Only one witness examined lordship, nothing stated against the present petitioner lordship, and lordship detention may be considered. Already they are in custody for 2 years, 8 months. He was arrested on lordship
26 for 20.
26 2000. Lordship.
When were you arrested?
Lordship petitioner was arrested on 26 2021. 2 years, 239 days. Almost 8 months, 2 years, 8.
What was the allegation?
Allegation, lordship, kindly have a look at Zahar, page lordship 13. There is a recovery of 201 grams of yaba tablet, lordship,
Page number 30.
201 grams. Without container, with container 280. And the one Siddharth witness was examined lordship. He stated nothing against the present petitioner, against both the petitioner lordship. That is at page 26, annexure 5 of the page. So, lordship on the ground of long intersection and also lordship, one driver and the lordship owner of the vehicle. Only one witness was examined till date. He also not implicated. Lordship,
What happened? Driver
not on that lordship. Most particularly lordship,
on
long detention.
long
Well, otherwise, that Caesar witness was their deposition examined on 31/3/23, and my lord, thereafter next date fixed on my lord 31/3/23. Thereafter, the order of this honorable court, my lord, on 29/11/23, my lord,
But despite the order passed by the honorable court, not a single witness was there.
present.
Not a single witness there. But
Till
only
now.
one after order passed by this honorable court, not a single. Lordship, kindly have a look at earlier order. That is order passed by this honorable court. That is that lordship, kindly have a look at page lordship 31. It is apart the portion of the order. It is further provided that the learned trial court shall examine the material witness and summon them and examine within a period of 3 months from the date of this order, failing which shall consider the bail application of the accused petitioner favorable. In spite of that order, notice
Okay, you appeared before this court earlier also.
lordship
That was rejected.
rejected,
With the
and
direct-
that was the observation. Also, honorable court asked to file a petition before the learned trial court. That was also filed. That was also rejected. My humble submission, lordship, long detention may be considered.
heard the application for nine code of that file that they put out at in behind the 26 code of for last year it that it is
What it is official case number 39 of 2021. 39 of 2021.
I think that what the was 17 it had lost its path for the option very much commanded that on the split one for the deep lab of the ASF the 7th battalion of the activity protection carried in charge of and during that it vehicle carrying prohibited drug was clearing the A and 70 was just and during that one night Java left wait 201 fire it around it traffic rate where as and another quick of good talk was shown that it's submitted by the when the charges were framed
What it does framed on 14/3/2020.
14 feet.
that 22
Yes.
20.
that charge framed 14 feet up it now it 1 feet has
And
been
that scissor witness was examined on 13/31/3/23.
submitted and state submit 31 and thereafter and paid 20%. It further submitted by an offset for even the fixer witness has not indicated present and has been uh, more, for more than 2 years and solely on the ground of prolonged incarceration. That will get bail. Yes. As per you have cited
Lot. Need to touch it.
by the apex court in Ravi Prakash versus State of Odisha reported in 2020 0 Supreme within bracket SC 707 and as per observation of apex court, Mohammed Muslim versus State NCT of Delhi reported in 2023 SC 135. The apex court has observed the aforesaid cases that the prolonged incarceration overrides the embargo of the 37 of the Indian Act. Where do you reside?
Okay.
Where is your permanent
Coimbatore.
Senate counsel for the petitioner has one permanent
Lordship, present petitioner is the permanent resident of Patal.
of
So
Qatar?
here the
Item
address is, my lord, resident of 14, 15, my lord.
Qatar and he paid that he and he paid that paid that of the other hand that he vehemently opposed the grant of bail of the quantity of contraband seized with the seized of commercial. Therefore, the embargo of section 37 is applicable in this case. Before Senate Council for Senate Council for also submitted that on an earlier occasion, the applicant approached this court by filing a bail application number 09 which was rejected by order. However, observation was made by a coordinated state order directing trial for submit of the material of state and it was also observed that failing which court considered application of bail of the have considered the that both or have and though this case involve commercial particular fact but for not clear it patient that as whether prolonged that it override the embark step it right. If it comes finding if it up if this court comes to a finding that the delay long enough for it some conclusion that the cargo of the step has been outweighed by fundamental right guarantee if that Article 21 of he may have released on bail by fourth paragraph of 12 fourth paragraph 11 12 8 13 14 16 from bail Quran and it has been named by 14 20 date of
Detention lordship 26 for 2021.
51
Lordship.
51 for last year and 51 and how many listed
Lordship listed witness 5,
8 mile.
8.
only one have come out of 8 listed and it has under such fact it's 40 and it was intention of it long enough and has outweighed the cargo of section 37 prohibition. Therefore, petitioner attend get paid. Fourth paragraph. What
My lord, one of the surety may be a governor.
1 lakh with 2 theory. One of the
They are permanent local residents. Who surety sometimes
how much
1 lakh
how much contraband
201 gram. 20.
considering fact that 01 gram
Lot.
200
200%.
then there are did not keep the keep some other with the bill up
Other people also same lordship. Right there out the same.
same
Yes,
kit,
yes, Lord.
same kit,
Same thing.
same date of arrest.
Yes,
Every-
he is the owner of the vehicle and he is the driver. Both were at the time of my lord recovery of test contraband, both were my lord together at this point of time.
Same order.
Yes.
Not second one, but
Both,
both
both.
are
I have both are arrested.
Address mentioned in the petition.
Lordship, it is 2 COT
two state
of like.
period of you are prepared. You are prepared.
At 2 p.m.
At then it
One article there, one letter that I have had for it. Apa?
here case number 9 that I think in the court of that and hereby interim order passed by this court on order date 8 to hereby vacate the registry of true seat of this the true seat is directed and back the case record immediately to the registry of that
Oblige, Your Lordship.
Also, I have an unusual prayer. The prayer applicant was directed to lead in the vacation court, but PhD has informed that there is no vacation. So I pray for listing on tomorrow. Oblige. Prayer.
this court can take up
Page my lord, this is an interlocutory application. To dispose of matter. Your lordship, my lord, just turn to page 45. Page 45. My lord, here, my lord, I was in the interim, I was given some bail by trial court, my lord, because my lord, my daughter, only daughter, is 90% locomotor disabled person. I have to take her to hospital every day, my lord. For that reason, I could not return to the court on time, my lord. So non-bailable warrant was issued. I approached this court gave me a 20 days time to surrender before the court. Now, my lord, again at page 48, your lordship will find from 12/10/23, my lord, 12/10/23, my daughter, I have to take my daughter again. My lord, I need just 2 weeks time, my lord, I will surrender before the court. That much protection. 2 weeks time, my lord, I will surrender before the court. My only daughter is 90% locomotor. I have annexed all the medical documents. She is unable, and your lordship's order also speaks as such. Your lordship will find in that. I will, in my lord, your lordship at the third paragraph, my lord, the trial
no,
court,
but you have not You have not complied with the directions of.
My lord, that is true, my lord. I have to take my daughter. I have nobody in the.
No, but for that you take leave of.
My lord, that was true. I bowed on my head. I bowed on my head. That is my head, my lord, my lord. Sometimes, my lord, because of the parents as for the daughters, my lord, I will surrender within 2 weeks. My lord. Within 2 weeks, sir. I bowed on my head for my fault. I surrender. 90%. 90%.
This testified by the petitioner, namely was granted after the bail. Bail was given.
My lord,
Surrender after interim bail.
my lord, after interim bail, I said. Then, my lord, I could not appear, so there was non-bailable warrant.
Was granted interim bail.
Page 42, your lordship may look it. Page 42. It's the extension of the interim.
Now what is page 45?
Page 45, my lord, when non-bail, I could not appear, non-bailable warrant was. First paragraph, your lordship will find at page 40.
I'm taking a, there is a small division bench for 5 minutes. After that, declaring for current counsel for submit that he may be allowed 15 days time.
Up to January 15th.
He may be allowed time up to surrender before the trial. An additional public ground does not considering the fact that as well as grounds mentioned by the petitioner for his default allows this prayer and time is allowed till January 15th.
Monday, it's the Monday.
Till January 15th to appear before the
Trial court.
trial court, that is the court of additional session judge
Number 2 now.
Nagam. And warrant is there.
My lord, warrant. Your lordship at page 46, last line.
Facilitate the appearance of the petitioner before the court of an additional session judge number as directly carried above, comma, the execution of non-bailable warrant of arrest against him by the trial court shall be kept in abeyance till January. It is after the interlocutory application in January.
My lord, sorry, no. A report was called for, my lord, regarding that whether case is pending or not, my lord. From Paltan case, I have received the report, my lord. No case is pending.
None appears for the petitioner on the other hand, that learned additional public prosecutor has produced the report as called for by this court by order dated 13 February 2023 as to whether any case is pending against present petitioner or not. It is stated by the officer in charge of Sultan Bajar Police Station in his report that as on date, no case is pending against the present petitioner. In view of the said report and the submissions made by learned additional public prosecution, this anticipatory bail application is hereby yes.
And our forensic lordship, I will regard the 37 regard aspect of the court or where it is being stated that the
Which judgment? What is your date of arrest
7/6/23 Lord.
and how many days you are behind the bar till today?
Eh,
6 months.
More than 6. Like, court.
No, that is all clear. Prakash has said that prolonged incarceration. But how long is that? How long is so long? Because Apex Court has granted bail in such cases where the detention is up to 1 year 6 minimum. You have not reached that. So 6 months is not, according to me, till now nobody is able.
That I prefer Satindra practice. Where this there
What it said. It also does not lays down that.
Article 21 or because bail is
No, that
so
is
that
that is observed by the Apex Court in Ravi Prakash also, which you have cited already.
that
Cited.
all
My query is how long is it treated by this court as long enough to give you benefit of? Yes.
Charge is not same, you know.
How it Miss M. Nirola done it. Counsel,
Charge it was submitted here on my lord 18/9/20.
but this is not long enough.
the witness has not been examined. It will take
No,
more time.
charge is not same. How witness will be exactly?
Exactly, Lord. The trial is in time. Yet the petitioner number 2 is above 75 years.
When the charge sheet was filed,
September 18.
also attested by the additional public prosecutor. This application under section 439 of the Code of Criminal Procedure, 1973 has been filed by the petitioner, namely Ranjit Devdi, alias Ranjit Devdi, alias Tirap Singh Devdi, and Shri Ganesh Devdi, who are detained behind the bar since 7/6/2020 within bracket for more than 6 months in connection with NDPS case number 54 within bracket CH/2023 pending in the court of. In which court it is pending?
Page plus 13.
Pending in the court of Tata. This case the facts relevant for consideration of the instant bail application, in brief, are in brief is that on 6/6/2023, the Triple Data had lodged an FIR for the officer in charge of study of inter-area stating that on receipt of an information that Naka checking was conducted, and during Naka checking, the how much was what was the recovery
3.320 kg of opium.
during Naka checking? 3.8
Zero.
kg was recovered from the petitioner from the petition, and from the transcript of said FIR, Sadia PS case number 120 was set and investigation was initiated. Ultimately, after completion of the investigation, charge sheet was laid against the present petitioner under section 18 of the NDPS Act. Learned counsel for the petitioner has submitted that though the charge sheet was laid on when it was laid, charge sheet
21,
20,
no, Lordship, 19, 20,
charge sheet was laid
18,
on 18/9/2023. However, it now charge Learned counsel for petitioner has also submitted that has cited a ruling of the apex court in Ravi Prakash for the state of Odisha, quoted in /20 SC 533, wherein it was observed that the prolonged incarceration, generally militate against the most precious fundamental right guaranteed under Article 21 of the Constitution, and in such situation, the conditional liberty must override statutory power created under Section 37 1 small b small Roman 4. Learned counsel for the petitioner has submitted that petitioner number 2 is 75 years of age and has been languishing behind the bar since last 6 months. The trial has not. Though the fixed court has observed in the above side ruling that prolonged incarceration overrides the embargo of Section 37 of the NDPS Act, this court has to come to a finding as to whether the incarceration of the petitioner is long enough so as to come to a conclusion that it outweighs the embargo of Section 37 of the The petitioner has failed to cite any authority where it could be shown, where we could show that for a period of detention of 6 months behind the bar in a case involving commercial quantity of contraband, the benefit of overriding the embargo of Section 37 of the Etiquette Act of Iran. Under additional, on the other hand, has opposed the grant of bail to the present petition on the ground that the quantity of opium seized is of commercial, and therefore the embargo of Section 37 of the Etiquette Act comes into effect. And comes into effect. I find justification submission made by the additional prosecutor. And though this court is of opinion that prolonged incarceration would override the embargo of Section 37 of the ATP Act, however, in this case, this court is of considered opinion that the incarceration of the petitioner named herein above is not long enough to give the benefit of such a benefit. And therefore, this court is constrained to dismiss the bail application act. Before parting, as in spite of the fact that charge sheet has been laid on 18 September 2023 for last 3 months, when charges are yet to be paid. Learned Court is hereby directed charges are yet to be framed, and as considering as one of the accused persons is 75 years of age, Learned Trial Court is hereby directed to dispose of the NDPS case number 54/2023 as expeditiously as possible. With this observation, bail application. Therefore, this expeditious direction
Evaluated, I think, 1812. Therefore,
service is awaited.
Yes, service.
One 51 picture. That not. Okay.
No, what has happened?
The notice I will have to.
Notice is not yet
Not
served
yet.
on respondent number.
Get the instruction from the concerned.
Heard Mr. A.R. Karim, Learned Counsel for the petitioner. Also heard Mr. T. Bhattakur, Learned Additional Purpose. Though the scanned copy of the LCR has been received as directed by the court. However, from the office note dated 18/12/2023, it appears that the report of service of notice on the respondent number 2 is not yet has not yet been received. Learned tomorrow. Will it be
No, I will have to get the answer immediately after vacation.
learned additional public prosecutor is requested to get the confirmation of service on the respondent number 2 through the officer in charge of jurisdictional police. Let a copy of this order be furnished and additional public prosecutor. Let this matter be listed again
On 11/1.
on 11/1.
May I prefer earlier date here, 4/5 years. Record it.
Fifth of the
Fifth of
Oblige.
Under
There are 19 charge sheets submitted, madam.
charge sheet submitted.
Yes.
Lord, white delivered a premature baby boy. There,
But the
Yes.
otherwise the allegation was for
It's under section 20B to C, madam.
commercial. You approached the trial.
Yes.
Heard Miss, what is your name? M. Saikia, learned counsel for the petitioner. Also heard Mr. P. Botaku, learned additional public prosecutor, who submits that though the case diary was called for in this case, however, in the meanwhile, charge sheet has been laid, hearing charge sheet number
947/23, dated 30/11/20.
in view of the fact of laying of charge sheet, this bail application is disposed of with an observation that the petitioner may approach a trial court and may seek regular bail before such court, if so advised.
Regarding child marriage, my lord, arrested on 25th of November, as on date, 6 days in custody.
The-
Have a pay order.
You have no what is there in the case?
Case diary not received.
What is your submission?
Yes.
Whether his custodial detention
Both are now husband and wife.
or Mr. D. Chak
P. How much?
D. Chak that is counted for also heard
Yes,
as they concerned counted for two, as well as Mr. P. Botak that is an additional purpose with application 439 of Court of Criminal Procedure, 1970 has tried by the petitioner Yvonne Colita, who has been detained behind the bar since
25th of November 2006.
25th November 2023 in connection with Prakriti case number 155/2023 under section 6/7 of POCSO Act, 2007, read with section 9/10/7 of the prohibition of that act, 2006. The list of accusation against present that on 24/11/2006, one Arup Chandra Das, who is the Secretary of Chandrapur Gaon Panchayat, had lodged an FIR before the officer in charge of Prakriti Police Station, inter alia, alleging that through reliable sources, the informant has come to know that the petitioner's name is Dibon Kul. Petitioner has married a minor girl and who is also pregnant for 3 months. On receipt of the said information, Prakriti should be case number 155. Learned counsel for the petitioner has submitted that. What is your submission? Otherwise, she is minor.
Otherwise, my lord, yes, my lord. But
That the petitioner is that the victim is the wife. She has delivered the baby.
no, my lord. She is pregnant. 3 months pregnancy.
The
Presently, the girl is in the custody of the parents.
The victim is the wife of the present petitioner and who is presently 3 months, who is carrying 3 months of pregnancy, and it is submitted that custodial detention
4 months, I think, at the time of
4 months, carrying 4 months pregnancy. It is further submitted that custodial detention of present petitioner would not be necessary as the petitioner ready to cooperate in the case. On the other hand, Mr. S. Deka, learned counsel for the informant, who is the father of the victim, has also submitted that the informant does not have any objection and the victim is presently residing. The learned counsel for the respondent who is the father of and what is your
Admittedly a case of my lord child marriage. But now
learned additional public prosecutor also fairly admitted that though it appears to be a case under prohibition of Child Marriage Act 2006, however, custodial detention does not appear to be for fair completion of target case 155. Considering submission made by the party before the court, this court is of considered opinion that further custodial detention of the petitioner does not appear to be necessary for fair completion of investigation of target case 155. In view of the appropriate thereby directed the release on bail of 30,000 to the Chief Judicial with following cannot make any threat, duress, or
deeply obliged.
Let me. Matter your lordship, 429 commercial quantity that they actually I argued your all and also submitted the list of the dates for two parts. First is with regard to prolonged incarceration. Second part, that default. So your lordship on that day I have submitted a sheet showing the date which your lordship
Okay, just let me find out that sheet.
that day your showing the date of the got, got. Here your lordship has seen that the fire was caused on 6/20/2020 and the person was also arrested on the same that is the part started at 6/2020. Your lordship, part 30 was fact was the IO has self stated that it is submitting part 30. The rest of the 30 is submitted later, and that is also recorded by the court. The court order on the part 30 was on 4/7/2020, where the court has specified the part 30 certificate. The remaining 30 is submitted later. Then your lordship cognizance on section 20 and 29 taken on 7/7/2020. Then charge was paid after about 5 months on 23/12/2020. At that time, your lordship we filed a bail rejected on 12/2020. Then your lordship the evidence part started from T2/2023, and it for the last 10 days only one out of the 7 only one witness has been examined. That is the actor. Not even your lordship the police officers have also not been examined as witnesses during this period. And your lordship the total jail custody on that day it was 638. Today it is 645. The only correct 645 days ago. So that I have argued on the ground of long incarceration. And with regard to the part of long incarceration, that the earlier matter of I just have a copy there. I thought I would have placed. Anyway, I was dying Ravi Prakash. Ravi Prakash, then there was the case of I'm handing over a few. If it is not there, it is there.
Lot of
I'm sorry, I'm trying to burden your lot. Then the judgment of our High Court judgment of the case. Then there is a judgment in case of Mondal and Topaz Mondal. That also I placed with the other case. I did not place it here. Then Nitish Otikari I placed that day. Nitish Otikari that day I placed. That was this case I did not place earlier because here it is 1 year 7. And Topaz Mondal and all are about your lordship normally nearly 2 years. This case exactly nearly. And Muhammad Muslim I have placed. Muhammad Muslim your lordship is there.
one is very good now. So it is actually I sorry put maybe that is by Justice Chaudhary. Report where 1 year.
Oh, yes, that. Then there are another one. If your lordship wants, I can place from our High Court. Only to three that whether the law. Yes.
Okay, yes, there.
Then the second part, your lordship judgment. Judgment. That day I placed the M. Ravindran. The other judgment, your lordship already passed the judgment that I can place. This judgment, your lordship covers everything. That
No, when it
yes, that is
when
what
it
I'm trying.
starts and when it
That is what
default pay.
default bill part judgment. Your lordship judgment. I'll just point out the paragraph where I'm denying it. Here, your lordship, in paragraph 18, 19, 20, 26, and 18, your lordship. Here I am taking up, your lordship, this because the Ravindran, your lordship, has quoted in this judgment, this part, where your lordship, the default bail continues to remain enforceable. In this particular case, your lord, they have not even filed the charge sheet till today. They have not filed the charge sheet. Then, your lordship, in para 19, your lordship has again taken up the judgment of Central Bureau of. Yes.
This case, present case, you have filed first bail charge. Not
Not.
so whether you have claimed or
That at that time, your lordship, we did not, there was no claim for default. It was not there in the application. I admit it was not there in the
so when it gets
That is where, your lordship, I brought in Ravindra, which says that it will not be extinct. Now, your
so it
lordship,
will
what
not
has
be
happened?
extinguished only if you have filed petition bail app.
Yes, yes. What happens, your lordship, if I have filed an application for call bail at that point of time, then it would have been a different. Now, your lordship, I have asked for a default. You can already also submit that. I have it is there in M. Ravindra.
Now you have your answer.
Yes, I'm now why I'm coming to that, your it is not extinguished because of the fact that M. Ravindran says that it will continue till the charge is filed or any other thing.
No.
Now till today charge is has
M. Ravindran says that the right to release on default will continue to remain if the accused has
applied for
such
such bail,
a bail.
not
Okay.
withstanding
Your
pendency of the bail
submission is
application.
still now charge sheet has
Not.
It's still part.
That is why here the distinct part is that till today it has not. So I am trying to point it that it continues. At that time I did not come to that. Well, today I have. So that part your lord will decide on that ground. So it will enforceable till I file a bail application and till the charge sheet. Now charge sheet they have not filed. So this part I think will be covered by this. This is my humble submission. Then in the next para 19, your lordship has again quoted Central Bureau in Kapil Wadhwa. This judgment also, your lordship, the only part will be the with regard to the same thing, your lordship. Good reasoning, and it was with regard to the fact that whether complete or Smith cannot defeat the basic purpose section 167.2 has been described here, your lordship, and court has held that the decision of the trial court was correct. The trial court has given the default bail. And here, your lordship, the court says that this sufficient evidence or not is not the question, because at that point of time, this is actually a after the, I think, the lordship will not go into the detail of that is what it is. And with regard to if there is two views, the main view is the one which will favor the accused. And then your lordship has also reported the judgment of 20, again your lordship, para 20. Ines Dalmia also your lordship has even quoted the Ines Dalmia in para 20. And then your lordship's own part, I will just point out that page para 26 and 29, lordship has given your lordship's lordship has stated we have in para 26 and 20. From the above judgment came to a finding in para 26 and 29. Here your lordship has stated that we have seen herein above that section is unambiguous term, while that the charge has to be submitted as soon as the investigation is complete, which means before completion of the investigation, charge sheet cannot be submitted. We have seen herein above apex court has observed it to covered. I'm not saying that first investigation should be completed only then a charge sheet filed and failure to submit. Charge sheet which is stipulated where triggered a statutory right of call bail to the accused under section 1 Code of Criminal Procedure. The right of default bail under section 1 of the Code of Criminal Procedure
here was healthy indivisible right. We have also seen that in M. Ravindran, here your lordship, Honorable Apex Court observed the right to be released on default continues to remain enforceable. He accuses applied for such bail when the right accrues to him. Here your lordship, it is continuing to accrue because they have not filed. This is what I tried for. Notwithstanding subsequent filing of tax. So they, in this case, they have not even filed tax. Then your lordship, we also have seen Dinesh Dalmia. Apex Court observed that the question as to whether the investigation remained pending on the date of submission of the charge. An investigating officer submitted the charge sheet only with the view to curtail right of the accused to essentially a question of tax. Here, your lordship, he has specifically stated in the charge sheet that the partner, and in the order also it is expected that he has submitted before the court that is remaining charge sheet will be filed. That is why. And then you got the question whether charge sheet, the investigation officer has submitted the charge sheet with only a few curtail the right of the. Yeah, in fact, thus the question as to whether in a particular case charge sheet has been submitted without completion of the investigation needs to curtail the right of the default bill. The accused must be asserted considering facts the consequences of. So your lordship, here the fact part is with regard to charge sheet and the order passed by trial court with regard to part. I relied on. Then your lordship, para 29. Now the question is as to how to find out whether the investigation has been completed or not on the date of submission of the charge. In my considered opinion, one of the ways to ascertain the same is from the explicit language with the charge sheet by the investigating officer and the officer in charge at the time of submission of charge. If it is explicitly stated the charge sheet that the investigation is pending, the right of default will be accused on expiry of 98 day of the. Here your lordship is one. Anyway, so here lordship has come to find that yes, it will come from the fact that what the IO has stated. Here your lordship, the charge sheet that I have annexed, the it starts from 31. The ASMEs was in page 30, the last paragraph. He has stated twice. The last part, your lordship, fifth line from top. I have also read that. Here he said, part অভিযোগ পত্র and second part again he said these 2 points I have pointed out on this ground. Then your lordship, page 30. This is the order.
The court
also said here the IO in the charge sheet has stated the final charge sheet would be submitted after completion of the. So here your lordship has stated that yes, the will be submitted after completion. So till today. So that my second part is with this. And the first part of long incarceration, your lordship, dates 10 days, and they could not even produce their own officer before the court. That
how many witnesses were
there were 7 witnesses, 1 examined, and that too was the FSL officer. Not a single. Forget about the independent witness, your lordship. Not even their officers have come up as witness. Not the IO. No. This is the direct case of your lordship prolonged incarceration. So this is my prayer.
My lord, yes. The charge sheet at that time was filed against these two petitioners, my lord. Of course, my lord, I have not seen earlier. Now I have gone to the order dated 4/7/22. That is reflected in the part charge sheet by the trial. But at my lord, subsequently, my lord, no other person has been arrested. Only these 2 persons. Against these 2 persons already charge sheet submitted on my lord 16/6/22. That is at 92 days, my lord.
No, I have given the chart.
Yes, my lord. They were my lord, arrested on 16/3 for production of 17/3. My lord. Then 92 days, my lord, charge sheet filed. My lord, total मतलब here मतलब found मतलब from a truck मतलब their time during Naka checking मतलब 4,60,000 of Yaba tablet. 4,60,000 Yaba tablet. 12.68 kg of methamphetamine cube मतलब and 1.5 kg of heroin मतलब. These are the मतलब amount. And
Here the police have very, very careful monitoring such large cases involving such large quantity of contraband. The monitoring investigation by superior of have to be very careful when you are submitting for the court charge sheet mentioning specifically that this part charge sheet and final charge sheet submitted after completion of
Yes.
yes.
Well, you notice no. Well, CRC does not provide for any part charge sheet and under clause 8 of 173 supplementary charge sheet. Now what I could guess from this, what I could understand after hearing my another friend and as well as my friend. Here it is mentioned as part charge sheet. And but the court has treated this as a charge sheet and frame charge. Trial began. Trial began and PW has been examined. And this is the right course of action. IO may write anything, but court will treat as per the 173 CRPC.
No, for trial, for conducting trial, consider whether materials are there to conduct trial or not.
That is
the different.
That is one aspect. That is
other,
already.
other aspect is no, whether to consider the charge sheet to be a part charge sheet or whether materials are there.
There is no provision for part charge sheet in the CRPC.
But whether the investigation was completed or not. Incomplete.
So far, yes, that is the point. When charge sheet has been submitted against these two accused, these two accused persons, court may presume that so far these two petitioners are concerned, their investigation in respect of those two petitioners is complete, and that is why the court framed charge. So far these petitioners, these accused persons are concerned, investigation in respect of these two petitioners are accused persons are complete. And there is further provision. There is provision for further investigation under subsection 8 of section 173. Maybe there are other persons are involved, or further evidence may be recovered by further investigation. That is why supplementary provision is there. Now, supplementary supplementary charge sheet is not submitted, and that is why court rightly treated this as a this part charge sheet as a charge sheet and frame charge accordingly. And while the CRPC does not provide part charge sheet, how the IO will file part charge sheet? Because the IO has committed some mistake, that mistake has to be perpetuated by the court also. That is not correct, my lord. That will amount to perpetuating the mistake committed by the IO, because he has wrongly mentioned part charge sheet. There is no provision for part charge sheet.
How court will find out
from the case diary and charge sheet. If the materials are there against the accused persons, prima facie, the learned court will have found prima facie materials, and that is why frame charge and trial began.
No, materials may be there on the first day of investigation. In some cases, then when to complete investigation, which authority, when to complete the investigation.
Since my lord, IO says that final charge sheet, there is no provision for final charge sheet. No provision for final charge sheet, no provision for part charge. CRPC only speaks about charge sheet and supplementary charge sheet on further investigation. Now, when my lord, the investigating officer did not file supplementary charge sheet, that is the, my lord, we may arrive at the conclusion that investigation is completed and no further evidence is collected. No further evidence or no other accused was found to be involved. And so far, my lord, default bail is concerned, my lord, your lordship know. So far, default bail is concerned, your lordship know. Against these persons, charge sheet has been submitted in due course within the statutory period. Now, my lord, immediately after, so question of, my lord, default bail doesn't arise for them. Yes, it would have arisen had there been any subsequent charge sheet. Then we might have presumed that yes, the case was not fully investigated, investigation was not completed. Here, my lord, supplementary charge sheet is not filed. Therefore, we have to, my lord, present. Since supplementary charge sheet is never filed, we have to take this charge sheet as final charge sheet. Now, on merit, what will happen, my lord, that is a different thing.
Regarding prolonged incarceration,
Trial has begun, my lord, commercial quantity involved.
quantity is huge.
Demanded. Demanded. No, arrested.
Mr. Manna,
Yes.
regarding whether it is part charge sheet or final charge sheet, that
That your lordship will have to go as
I
part.
will go through.
That part your lordship has also cited in the other.
But
That it will be on the facts of circumstances.
Considering the facts of this case, considering their
With regard
and with regard to prolonged incarceration,
prolonged incarceration, your lordship, I have already submitted.
but whether the quantity of contraband is also a relevant material.
So your lordship,
Suppose in a case of heroin, more than 250 grams is commercial quantity. An accused is apprehended with 255 grams. He is also a commercial. And in your case, it
is more.
5 kgs or
4,60,000 yaba tablet, 12.68 kg of methamphetamine cube, and 1.5 grams of
heroin.
so whether same yardstick would be applicable.
Your lord, this is what
Because the ruling cited by you of 1 year 6 months.
1 year 6 months, your lordship is one. But mainly your lordship, Ravi Prakash, your lordship.
But in Ravi Prakash case, which lays down the principle
Of 37 will not be.
Okay.
Here, your lordship, what I am trying to point out, kindly take up for a moment page 43
of the
bail application. It is heroin and methamphetamine tablets. These results were positive for page 43, last paragraph, result of examination. A positive test for heroin and the percent of heroin in the exhibit found to be 5.57. And 2 is the exhibit a positive for methamphetamine. So methamphetamine and heroin was. It is true. That is, but the percentage of heroin is very low. One thing I am saying, because this is too low. Anyway,
what is the percentage?
It is 5.5, less than 10%. 5.5. So it is basically, I think, normal powder. Hardly anything is maybe a little bit of 1 or 2 drops of heroin must have been.
That is also relevant.
That is one part. It is on. I'm not on the relevancy. I'm saying that these are the two aspects. Then you
while considering
yes. How is the total quantity? Then a quantity part, your lordship, when why I was trying to point out with regard to the quantity part, massive quantity or the commercial quantity up to 250, more than 250 gram, absolutely correct. It's a commercial quantity. Now, your lordship, question is whether the prolonged incarceration will look into the quantity or will go by Article 21 of the Constitution. No, when I am arguing on prolonged incarceration, the part of the merit part of the case is not there. That will be proved by the court. I may be punished, I may go to jail 20 years. It is the maximum punishment is there. Prolonged incarceration is with regard to Article 21 of the Constitution. Yeah, it will override. It says, your lord, it will override all the other your lordship act, because the Constitution overrides everything. There's a judgment, I think it is there in Muhammad Muslim, which says that it will override everything. So that part, number one, my point. That once your lord, commercial quantity, all are commercial quantity, some are more, some are less. The question here, your lordship will have to look into when it is prolonged incarceration. Your lordship will have to look into the whether a person is now. This is the question of fact that he is not the convict, he's an accused, not a convict. He is an accused. He may have done, may have not done. That court will decide. Thus, because of that, your lordship, it is the prosecution's part to come. If such a huge quantity, they should have done it, your lordship. Their own officers, 5 officers out of 7, 5 are the officers of the police. Why they have not appeared and completed the evidence in the next 10 days for the last 1.5 years? What stopped them? That is one point. Prolonged incarceration will come when they are not doing that. They are taking it as a trend. That yes, let us first and foremost arrest this person and they will be in jail for 10, 20 years. Doesn't matter whether we do. That is why court has come up. So Honorable Supreme Court has come up saying that yes, if you are not doing your duty correct, you are going to suffer. Now it is a fact. The trial will always continue. They have to they have to face the trial. It's not that once your lordship grants bail, the trial is gone. Just on the guise of 37, your lordship, this type of 37, the counsels for the respondents always come and really make a good submission, your lord. But that enthusiasm should have been there in the trial court. Finishing of the trial, get their officers first.
Okay,
5 officers.
I'll
Finish
have,
it off, your lord, as early as possible.
I'll have to consider this technical part, this part that is
That part, your lord, will have to go through with on the basis
Record.
of the fact of that part is in prolonged incarceration, your lordship. Absolutely, this is the case of prolonged.
I'm reserving,
My lord.
reserving the
And
So
with
for myself,
prolonged incarceration, since I have not got the other judgments, I'm placing those judgments again before your lordship so that your lordship could or your lordship, I can produce it now. I have
no, that is enough.
to be precise, my lord,
Muhammad Muslim was also there.
that is the only ground for my line of defense, prolonged incarceration. That is the only ground. So for default bail, before he is not entitled to any default bail because there is no supplementary charge sheet. If this charge sheet has been
That I will
completed-
examine.
Yes.
That submission, that
Yes, yes.
whether
Your
in
lordship
this
may kindly-
case he is entitled to default bail or this is a question.
Yes, your lordship has also helped in the other.
Now, though it has been written in the middle of charge sheet that part charge sheet, but Lionel Trial Court has treated it as final charge sheet under section 173. So, since there is no further charge sheet, my lord, no question of my lord default bail. And that is a mistake on the part of the IO, not
Heard Mr. White has not counsel for the petition. Also heard Mr. He does as well as KK Parat has the petition for the order. I'm not giving a date on reopening first week.
Delivery of orders on the next.
Let this case be fixed for delivery. Then I have to give 6 days.
up to your lord. Never your lordship, but lordship can is the matter up to your lordship. Needs to be a given a big thing, but it cannot take it as a reserved.
Let it first week of calendar the date of
It is
date of
yes. Will be second.
therefore I am not using the word first.
Yes, because we are reopening on I think third.
Yeah.
So your lordship can get it time.
On 8th of January. Because this question is complicated.
Yes.
This first part. Second part it may not be. So 8th of January.
But on the other day, your lordship has this matter that from the brothers, the pharmacy of the petitioner, some contrabands were recovered. The brother of the petitioner is a medical practitioner. He is having Vedic drug license. And your lordship wanted to put a query on PPA that whether after that case diary, what is updated here, after that whether any material is found on. So he is supposed to tell whether.
Yes, my lord, we have received written instruction from the IO, my lord. FSL not yet received, my lord. Today is the 138th day, my lord. FSL not yet received, and IO stated that at the time of search and seize, my lord, there are independent witness, 2 witnesses are there, my lord, and no other witness has been examined.
Independent witnesses have mentioned that
Mal-
he
mal-
from pharmacy.
Yes, pharmacy.
Pharmacy belongs to his brother.
That is clear, my lord. But only one fact I am telling, my lord, that the accused himself said that I used to sell cough syrup bottles without prescription, and he don't have any my lord, slip or any paper that he has purchased in genuine purchase those cough syrup. He has not purchased them in genuinely also. My lord, he has purchased it from a person of Korimganj. He doesn't know his name. His statement, my lord, may go and.
But his statement
Oh, on 61, my lord, yes. On 61 statement is there. At this stage, my lord.
what is
Yeah, that lordship judgment is also there. One thing is also there that that cannot be the basis of arrest.
you are relying on some public or Mr. A. Any you want to submit any
Lordship not there. If people are to, I will take. One thing is already there.
or Mr. A. Ahmed counsel for the also heard A. K. Parashar this application for under section 439 of the Code of Procedure has been filed by the petitioner was arrested or filed by the petitioner the Premjit Paul was arrested on
5/8/23.
5/8/2023. How many days?
138 days, my lord. Till today, my lord.
For last 138 days. Within for last 138 days. In connection with Brotherhood PSPS for 199 2020. Under section 20 of the APPS. The gist of expression is that on 5/8 of month, name of
Notice
for
of informal in paragraph 3, I have stated Topical Islam.
Topical Islam Mazumdar Malak of
the
FI Bodorpur.
side of and all by devotee of the church of Brotherhood, Territory, ethic that on after receiving an information Bible sources that petitioner is selling illegal substance in his pharmacy. A team of police along with first information went the went Kalachand's medical house at Sirigori Bazaar and he number 8 brown colored plastic bottles containing 14 phosphate for one. Number 27 number of 8 plastic colored bottles also containing 14 phosphate syrup. 10 numbers of tablets with brand name Colantron. 4 numbers of tablet strips of Colantron and 2 numbers of tablet strips of Colantron. Again, 3 numbers of tablet strips of Alprazolam and 6 numbers of brown colored plastic bottles with containing 14 phosphate with brand name Instacot. Petitioner was arrested from state place. Senate Council for the Petitioner has submitted that pharmacy from where the mentioned contraband was belongs to the brother of the present petition, namely
Premjit Kaur.
Premjit Kaur, and he has
Brother name is Prasenjit Kaur.
Prasenjit Kaur. Prasenjit Kaur. It's also submitted by the Council for that the brother of the petitioner has the valid license for pharmacy, namely Mr. Kalachand House, and as per the terms and conditions of the license, as well as 61 of which route terms and conditions of the
Terms and condition of the lordship that he is only not authorized to schedule X drug, to keep on the schedule X drug.
the pharmacy of the brother of the petitioner is licensed to sell, stock, and exhibit
Drugs excluding those specified in schedule.
excluding those specified schedule drugs. These are not
No. Schedule X drug is I'm giving the book.
no, I will not make Senate Council for the petitioner submitted that the drug seized by the IO state are not Schedule X, and therefore the conditions of license of granted to the pharmacy of the brother of the petitioner is not violated in any case. It is further submitted by the petitioner that the that the brother of the petitioner, Prasenjit Pal, is a registered medical practitioner of alternative medicine and substantiate submission and its counsel for the petitioner has referred the Annexure 5 to the bail application wherein he has annexed the what the of the brother of the regarding his regarding regarding certificate held by him as registered medical practitioner of Senate Council for the petitioner has also submitted that at the time when the seizure was made, the brother of the petitioner was not in the party, and death was death. Any other
Because that thing there and the articles were recovered from the
and
pharmacy.
all these articles were recovered from pharmacy of brother of and not from the Learned Council for the petitioner has also submitted, though has been submitted that though the prosecution has relied on the statement made by petitioner that authentic is for investigation. However, as per as per ruling of as per observation made by the FX case of fasting for Union of India reported it for the statement made by the of this act, not an visible name cannot be where are the Caesar petitions?
Well, witness like
On the other hand, the additional public prosecutor has submitted that contraband seized case are have also gone through the case side of other on basis of that we have stated that it's it for the that there that there contraband was made, the recovery of each contraband made from pharmacy of however from the pharmacy of
Rather the they are not saying, they are saying the pharmacy of the
whose pharmacy
pharmacy belongs to the register. It has registered.
My lord,
And
he,
the document
his
is by the
statement,
investigating officer also given to the Zimma of the petitioner. That order I have accepted. Because he is the registered owner, he is the owner of that Kalasan Medical Hall. Therefore, all the documents relating to pharmacy was handed over to page 27 of
where is
page 27.
pharmacy of however page
Page 27. Second paragraph, document and it may I read?
where is
His brother may be my lord, actual owner, but he is running the pharmacy, not sitting only on that thing. Because the independent witness said that he is pharmacy. Only because maybe on that level, maybe he is using his brother's license, he is running the
how it appears from the license the Jimma of which was given to the registered owner. License of pharmacy, namely Kalachan Medical Hall, the Jimma of which was given to the registered owner by order dated 29/9 passed by that that the registered owner of state pharmacy one Prasanjit Paul, who is the brother of Prasanjit, and and Prasanjit's false statement is not recorded. And the investigation of how many days you are behind the
just collected the documents from the investigating officer. That investigating officer was directed to hand over the documents. Maybe I have not seen. Once Marat may peruse the statement of the accused. Regarding that statement, I have given one statement of- and Honorable High Court has granted him bail considering that one thing is applicable against that order. That order was challenged by Supreme Court, and Supreme Court said that order was first right because by applying the principle of paragraph 10 of that order.
on paper of case that it appears that apart from statement of youth that got it that but yeah, there is no convincing theory process that prevent that Kala got it. Or not that it come finding that there are come believe that petitioner for offense rather on the basis needed available data as well as on its at this stage for purpose of consideration of bail application it can be said that there are some find that the petitioner is not guilty of the offense alleged against him. There is also no material on record to show that in the event of granting of bail, the petitioner would commit any offense while remaining on bail. Therefore, in view of above, petitioner Premjit was thereby allowed to bail of 3,000. Very preferred. Right. 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 Oh. People. It is pending.
Investigate. That's it.
Cannot leave instead of trial court with the special cannot leave the special judge Karimganj during a issue of other that go further.
The judgment Tufan Singh as a state of Tamil Nadu reported it 2021. 4 page 1. State of the Union of India state of Tamil.
My lord, before my lord starts, my lord, we have received the case that in both the cases of 45, 46, my lord, it's a voluminous case, my lord, we have not yet gone through, my lord. And here, my lord, only I have gone through the FIR, my lord, it's necessary, my lord, because here, my lord, one investigation is going on regarding an NDPS case. During the investigation, I have found that some accused of that case were also involved in a case where they are facilitating Bangladesh nationals to come across India. They are facilitating all these PAN card totalization and all this they are preparing. And the fresh case again, this case is registered. So we have to go through detail in the case that is not possible.
Our names are not there in the FIR.
You are in jail.
Yes, Lord, since 9/11, 43 days later. Subsequent to their,
But they have.
yes, yes.
And here several passport act
Passport Act is there.
all are here
Third
So-
method, third method, third taken by the petitioner who submit so the case diary is available. Case diary is available. How it is voluminous. Voluminous. Therefore, some time is required both before submit later. Submit later. Moment
here
get fifth of fifth of this is the case that
this is the we have not even open my lord.
Relating to sideway petitioner before your lordship is the husband. He is behind the bar for 80 days.
80 days.
80 days, sir. Suspected case, sir. Lord,
Who has appeared for wife or who is respondent?
Lord, one
And now, one had born on 10/11.
Child born.
technically minor, now 7 months pregnant. Look, at present, lordship, one child. Sir.
Why? Yes, Mr. Paul.
Otherwise, admittedly minor child marriage. It takes a track of
This is pending trial. Where the girl lives. What is the sub?
now my lord, both are husband and wife. So custodial interest may not be necessary, but admittedly, my lord, case of child.
Third, Mr. M. Khan, that for thought the keyboard of that statement of as well as that they are parties that counsel appearing for respondent of the who is the father of this application, the court has made court of has been filed by with petitioner if Sanidu who has been stayed behind for since 310 for last 81 days in connection with special case 124 within bracket M /20 arising out of money CSM on under section 9/10/7 prohibit that of 6/17 of the and section of the gist of it that or three then of one Ashok Kumar that has not had before officer Hitler had married a 16-year girl with and therefore violation of child marriage prohibition and counsel for the submitting the charge sheet when it charge sheet was made.
On 31/10/2020. 31/10/2020.
Charge sheet was laid the case on 31/10/2023. 23. And case and special case special P case 154 that pending for the court of where it is special that provide of at stage of evidence whether evidence has been
No. But if a charge is
the stage of consideration of charge and is further submitted by the counsel for in the meanwhile further submitted by the counsel for petitioner husband of victim girl in the meanwhile victim has delivered the
your 10/11.
content that victim is deciding her father done it counsel for the format done it counsel for the respondent of the who is the father of the victim has also submitted that the victim is deciding with the respondent of the and he does not have any of the bail but the other hand the petitioner submits that though there are serious though there are discriminating serious of custody may not be if the operate considered the but the fact that has are further does not get in the other operate to that their date of that subject important data and
Wait, please, your lordship. Lordship, this is a 439 tail application, lordship. Only the LCR can be called for, lordship. It's a
Mr.
capital case.
P. Chaudhary also
Notice to Komal Proctor.
Yes.
let the notice be the respondent
To
as per the mode prescribed by this court by a division bench of court for the as permit petitioner for yes, respondent want no court let the hand copy of case report for from prior
the special judge Bakta Muthu. I live. Maybe reopening it.
Take time.
Publish.
462 my petition, my lord. It's a kindly see, my lord. State, my lord, that is FIR was lost and thereafter it was submitted, trial was going on. And thereafter, my lord, page 14, my lord. So maybe the annexer to page 14. Last line, my lord. On 4/7/2020, accused is present along with defense witness, but engaged learned counsel accused has sought for adjournment of the case to the ground of the engaged lawyer, senior counsel Mr. So-and-so having I element so-and-so. Next, my lord, 27/2023, my lord, senior counsel Mr. Hawk has been admitted here at the hospital. And thereafter, he was in Narayana Hospital, my lord, for open heart surgery, page 17, my lord. My lord, this is a cardiac so-and-so, post-cardiac so-and-so, arterial bypass surgery was done, my lord. So thereby evidence was not given, my lord, on time, my lord. On page 18, my lord. This is the impugn order, my lord.
Yes.
Page 18, my lord. Accused Zahirul Islam is absent today with 17th petition file engaged learned counsel accused heard the prayer for party allowed for another date for given for appearance of accused, but prayer for adjournment DW evidence rejected as because defense in site since so-and-so 25/2006 taking adjournment showing various reasons. And this court has given the adjournment end of the but today prayer for adjournment of the defense witness evidence cannot be deferred another date in view of several dates have been taken for the same. And as per the statute, this instant case has to be disposed of with 1 year. And at the time of consumed for the disposal of the case has been over more than 1 year. In view of the above fact, reason cited above, adjournment legally rejected. And thereafter, my lord, next is 20, my lord, last 20, my lord. My lord, by closing the DWT, my lord, and fixed for next purposes judgment on 26/12/2023, my lord, is 20 last. My lord, but one thing is that, my lord, Planet Senior Counsel in bypass surgery in Narayana, and my lord, due to my lord, problem of the advocate, the client could not suffer. He has taken a DW witnesses by accused taken, my lord, but due to the default of the advocate, my lord, for the purpose of health, my lord, he has not given it the DW. So my prayer, my lord, is page, my lord. So maybe the captain against his judgment on 26/12/2020.
No,
Because of that natural justice has.
but when will you reduce the defense?
My lord, within, my lord, 7 days or 10 days.
You will reduce.
Yes, my lord, definitely. Your lord, fix the date of January any date. My lord, otherwise, my lord, natural justice, my lord, violated because of that the case. Yeah, but he has accused, has taken the DW witness due to ailment of the advocate as a bypass surgery. Thereby, he has not been taken time. Particularly, he is a pilot laborer, my lord, as a daily laborer.
Court is also under pressure, but he has to, but here, genuine problem.
One chances.
One
January any date.
No further date.
Yes.
Third, Mr. N. Bora.
Niran.
N. Bora, the council of God. Certification. By petitioner. Zahirul Islam. Tuning deposit 31 8 passed by court of prayer for prayer of the petitioner gives defense witness both and case was fixed for next day that Learned Counsel for the petitioner has submitted is that petitioner contesting case against pending against him, contesting the case that is petition for case 2020 pending in court of petition court. However, and he has engaged the F house as his counsel, submitted by the counsel for the petitioner. Though the case was fixed for using defense evidence on 31 May 2020, however, as the engaged as the counsel engaged by the petitioner had some what is the suffering from?
Bypass surgery, madam.
Had some medical issues and had undergo bypass surgery.
At Narayana, NH Narayana.
At where?
Madam, page 16, madam. This is the discharge certificate, EMA is the hospital discharge center, page 17, madam. EMM hospital and discharge center.
Therefore, it is not clear that the petitioner had filed an application for the discharge showing cause of praying for an adjournment for using defense of same was rejected by the on the ground that petitioner has been repeated adjournment since the month of May. And therefore, month of Learned Counsel for submitted the petitioner not allowed to give the highly treated and accept the praise for at least one charge. Now, you can of considering the Learned Counsel for the petitioner has furnished some medical documents, including the discharge certificate, which shows that the F was F had been suffering from coronary artery and have undergone surgical intervention for coronary bypass. Considering the fact that the petitioner appears to have genuine cause in not being able to give defense evidence on 31st date, 8 August, case was fixed for trial. Also considering the fact, however, also considering the fact that has taken separate adjournment for reducing the one airback. Before that, somewhere, an edition of the prosecutor has fairly submitted that, considering the grounds mentioned by the petitioner, at least one chance may be afforded. In view of above, when its airport is directed, allow petitioner at least one chance value in his defense witness by fixing any suitable date the month of January.
Right.
However, it hereby made clear no further indulgence should be granted present petitioner under any circumstance. The above observation is criminal petition that a copy of the furnished
My lord, the order dated 16/12 was for judgment.
not kept in as referred
Right.
view of the direction of
So, मतलब he will appear within मतलब first week of January. Then
I will appear to
Planet-
26th. I'm going to
the
appear.
petitioner shall appear before the that on 16th of December on which date
26/12.
26th of December which the case is fixed before on which date the case is fixed before Planet and on his appearance the Planet on his appearance the trial court would defer the delivery of judgment fixed date and give opportunity as that date.
Intellectually application is appeal. Appeal may be taken.
What is the
It is up to IA has been filed for correction of post-status. The main case, the appeal may be taken. 30.
so item 30.
30.
Yes, 30.
Appeal may. In this,
no, what is the urgency?
Dr. Ati is behind the bar, and from last 42 days, the date of judgment, here in this case, there is no physical car. Even then, he has been convicted.
POCSO.
Even no car.
Notice will have to
Yes, the notice issued and the respondent already appeared. For 8 hours.
now why this interlocutory application?
One for suspension of sentence and two for correction of post-status.
No, I have not noticed. Why I have to file this interlocutory
For
Correction of post.
post title in
it of in IA, one for suspension of sentence and correction of post-title of 18.
then let first it has to be corrected. Thereafter third Mr. 8 is Sarkar, then it comes for the third Mr. K.K. Pulakar. This application, this interlocutory application has been filed by the applicant, namely Ibrahim Ali and Kiara Ali, Ilyas Mohammed Kiara, praying for allowing the applicant to correct the cause cited as well as prayer for portion of memo of appeal in criminal appeal number 428/2023, as well as there is another interlocutory application.
Yes.
Where you want correction in memo of appeal only,
Memo of appeal and IA for suspension.
as well as in interlocutory application, as well as in the petition. In interlocutory application number 1129/2023. by what correction you want?
For case number, we have not meant.
By
Case number not.
by inserting the session case number SPS special box of case number 24/2020. Only session case number.
Yes, but only
Why it was not inserted? Learned counsel for the petitioner has submitted that this omission was due to inadvertent error on the part of the petitioner. Considering the submissions made by the counsel for the prayer is allowed. The applicant has take steps for correcting the false title as well as prayer portion in the memo of appeal as well as the appeal under section 389 of Code of Criminal Procedure filed by the person that you take steps the interlocutory application as well.
it will make.
These appeals are to be placed again after making necessary.
We could take another 5 load.
We don't have any option because interlocutory application is allowed. Now you have to take steps for giving corrected type copy of the.
We have looked annexed with the annexed.
It is to be filed in the filing section. It has
Then to maybe taken up 2 more. I'm arguing that in the meantime. So I'm an innocent person behind the bar. Otherwise, never better I thought. 2 more lot. Maybe in the meanwhile, we have corrected the
let this in item number
30.
Let this item let this matter be listed again tomorrow after correction of first title as well as clear portion of memo of the as directed in the interlocutory application number 1273 by as directed by order dated 21/12/2023 in interlocutory application number 1273/2020.
Hello.
Pilot accused petitioner Bipular Rodriguez, pilot arrested on 10/11 at charges under section 407 and 421. Accused petitioner is the driver of the informant. He took rupees 1,50,000 from his employer with a view to release his vehicle, which was in the garage, my lord. On the date of incident, my lord, while he reached Katabari market, the entire money was theft. Accordingly, accused petitioner lodged an FIR with the police of the Jalukari police station and informed his employer. And informed came, his employer came, and he himself lodged an FIR against which the accused petitioner was arrested.
You also
Suspecting myself to be involved in that.
You also lost an FIR.
Yes, my lord, earlier. That I have an expert.
Then this
He is the driver, my lord, and informant is the owner, my lord.
since when you are arrested,
My lord, 10/11, my lord.
Today is 41 days.
42 days.
whether he is detained,
Order detained. May not
how
be
it makes that. What is your name?
H.
Soikia, and at council for the also take a press. This application at the 439 court of by the petitioner Kamaleshwar Deka, who is detained behind the bar since 10/11/2023 in connection with Yadupari PS case number 661/ under section 120B/407/420 of the Indian Penal. The gist of accusation indicates that on 9/11/2023, one Sri Oren Burman had lodged an FIR before the officer in charge of Jalupari police station that the petitioner, who is the driver of the first informant, was given rupees 1,50,000 by the wife of the first informant for releasing his vehicle. From where he releasing his vehicle?
Garage at Sato.
From the garage at Satgam. However, it was informed by the present petitioner, the informant, that some miscreants have snatched away the state money from him at Adabad bus stand, and informant now suspects the involvement of present petitioner in misappropriating the state money. Therefore, the Learned Counsel for the petitioner has submitted that petitioner is in no way involved in offense alleged against the fact. He on submitted that on 9/11/2020 reached near Adabari bus stand. Some miscreant had snatched away the money given to him by the wife of the first informant, Oren Burman. It is further submitted that in this regard, the petitioner has also lodged an FIR.
Yes.
Before the Jalupari police station, even before lodging of the FIR against him. Learned Counsel for the petitioner has stated that considering the period of detention, that is of 41 days, petitioner may be allowed. On the other hand, an additional prosecutor has produced the case diary of Jalupari case number 6 and submitted that. Is there
Yes, because otherwise the locality of that area where the accused person stated that incident occurred, the witnesses stated that no such incident occurred in that area. So there are strong reasons to
there are
suspect the
material suspect involvement of the offense, the FIR. However, considering the period of detention already undergone, the material to suspect involvement, I have considered the counsel for and have verified on record, including the case diary of Jalupari case. Considering the progress made in the investigation as well as the period of detention already undergone by the petitioner, his further custodial detention does not appear for fair completion of the investigation of Jalupari PS case. The above petitioner is thereby allowed to go on bail of 30,000 subject satisfaction done at chief petition. Approved.
Matro.
In this case, Lordship already.
Well, 49 today not possible, madam.
Already, Lordship, 50 number of accused are seated in the charges, Lordship. Almost all the accused released by the court from the High Court as well as from the trial court. And
Case there is
No, LCR is received, my lord. The voluminous, my lord,
Mustafa
LCR.
case.
yes.
No, there are some-
He has
There are
been
serious
arrested.
allegations
But
against-
every case of every
Yes, yes. In
he-
view of my lord, section 43, my lord, 5D of the UAP Act, my lord. Specifically-
that allegation is not there in the
charges are framed.
after framing of that, this order has been passed lordship, on lordship.
In this type of cases,
812,
parity cannot be
812.
claimed, my lord. There are, my lord, sufficient, my lord, material. The
He is-
Sufficient-
link with, my lord,
sufficient
Al
material.
Qaeda, my lord.
No,
No, let me make it sufficient before that he wants time to go through. That is his topic.
can it be tomorrow at 2 lord?
Tomorrow also, lots of cases already listed. These are, my lord, serious matters, my lord.
Because all sitting behind to are tomorrow with paper.
If possible, lordship, at 2, if possible. Because already in one case, lordship granted bail, and this is shown arrested bail. And after framing of that, the other co-accused.
Tomorrow I will have to also go through many other LCRs, many cases, my lord.
If
Again,
possible, lordship,
my lord,
last-
because
last
this is
day,
not a
let's try his luck, lord.
Okay, if it reaches,
if this is, my lord, can
2 lord,
no,
as a last item, lord.
others are also having said on entry matter are there.
Today. My part, maybe RTA tomorrow, and then if time permit. Like, as a last item, if possible.
My lord, item number 38, my lord, maybe first week of January, my 30.
Court master will
My lord, today's item number 4, my lord. After my lord, not let January, be again, my lord. Previous wait, my lord.
no.
Okay.
Let us see. Court master will pick or whichever is
Right.
very, very urgent. Try to execute.
Item
Yes,
7 also the same.
We take it for class. That's why 27. Both accused my preparing exhibit without instead my tenant. That is why I made it. Tomorrow will get. Tomorrow. Okay,
My lord,
that is
item
the same.
number 4 also, my lord, that is.
Lordship, item number 25, Lordship. The co-accused has already released on bail even Kesari is available, Lordship. So I am a government employee, Lord. So please, for tomorrow, Lord, or Saturday.
But tomorrow I will sit only up to 4.
25.
My lord, regarding item number 57, the hearing,
Highly
appeal, my
obliged,
lord, hearing, there is a court date, my lord. Matter has come up for hearing and next sentence.
Not today is the 4th day because of this.
No, my humble submission is, my lord, maximum, the punishment is 3 years. I have already undergone 2.5 years of imprisonment, my lord.
Let it
So
be
come on,
first week.
fifth, my lord.
My
This is-
lord, it does not appear, my lord. But it appears, my lord. It is prepared. Prepared with my
No, I have your matter. When do you,
lord. Tomorrow, my lord.
My lord,
My lord,
item
item
24, my lord, this is the third day, my lord, CT has not come. Kindly make it tomorrow, my lord.
My lord,
Kindly
item
tomorrow, my lord.
tomorrow I will see the same.
item 29, my lord, it is
24
there, my lord.
tomorrow, may I
Tomorrow,
pray,
my
my
lord.
lord. 24 tomorrow.
29
30
also
also
tomorrow, my
tomorrow,
lord.
my lord.
It is there, my lord. It is there, my lord. I will try, my lord. I will take a Shanti visit.
Take dates from 4.
29.
My lord,
29, my
34.
lord.
Let me
Twenty.
both.
Obliged.